Hi, family. Welcome back. Twitter, Facebook, and ScrewTube. I guess they're a little late back from lunch as we're at 1:33. We were due back at 1:30. So I'm just waiting for them to return. I've refreshed the screen. So it's just a waiting game at this point. Hi, Yaira. Yaira. I hope I'm pronouncing that right. Welcome back, my love. They're still at lunch, but we're here, waiting with bated breath to see what's next. I hope what you learned from the first half is that they absolutely have the money to repair us. Now we have to work on their will to do so. And a lot of people are asking, why is there so much diversity on our task force? Well, there's so much diversity in our state government. Okay, Yaira, 10 minutes late, the first part. Yes, you got it. I think we are neighbors in the LBC. Oh my goodness, we must connect. We must connect. Hit me up at the rep perspective Gmail. Let me wave my banner. Hit me up so I can connect with you. This is awesome. Most of the comrades are in LA and in Sacramento, If we definitely they do. If we didn't know, we do now. Oh yeah, COVID-19 is a prime example. All the money they're pouring into the Ukrainians to fight the U.S. war with Russia. That's exactly what it is. You don't send practically $1 trillion to Ukraine if this ain't your monkey and your circus. Come on now. Oh, I would love that too, Yaira. Please, please. My daughter's in college now, so I can go out and play with my comrades. I don't have to run around from here, there, and everywhere.
All right, everyone, we're going to get started. Before we get started, I'll turn to Parliamentarian Johnson so that a quorum can be reestablished.
Here we go.
Thank you. Thank you, Madam Chair. I will begin with the chair. Chair Moore.
Present.
Vice Chair Brown.
Present.
Vice Chair Brown is present. Member Bradford. Member Bradford is absent. Member Grills. Member Grills is absent. Member Sawyer. Member Sawyer is absent. Member Holder. Present. Member Holder is present. Member Lewis. Member Lewis is absent. Member Montgomery Stepp.
Here.
Member Montgomery Stepp is present. Member Tamaki.
Here.
Member Tamaki is present. Madam Chair, there are 9 task members, and the number needed for a quorum is 5. And let the record reflect that Member Lewis is present, as he just entered the room. There are 6 members present. A quorum has been reestablished.
Thank you. Now that a quorum has been reestablished, we'll return to our agenda. The next item on our agenda is item number 18. Witness panel principles for effective reparations initiatives based on domestic and international human rights laws and norms. I also want to note that we have Professor Bush on the line listening in the event that task force members have any comments or questions for Professor Bush. Any comments or questions for Professor Bush at this time? We'll now turn to introducing our first witness, which is Michael Cochin. He's here, he's remote, he's joining us remotely. Michael S. Cochin is a professor in the School of Political Science, Government, and International Relations at Tel Aviv University. He received his A.B. in mathematics from Harvard and his at 19 from Harvard, and his MA and PhD in political science from the University of Chicago. He has held visiting appointments at Yale, Princeton, Toronto, Claremont McKenna College, and the Catholic University of America. Professor Cochin has written widely on the comparative analysis of institutions, political thought, political economy, politics, and literature, and political rhetoric. He has published 4 books, including An Independent Empire, Diplomacy and War, and The Making of the United States with the historian Michael Taylor. Before Mr. Cochin presents, in the interest of time, I'm asking expert witnesses to truncate their testimony. So unfortunately, I'm sorry about that because of our technical difficulties. So if you can, please conclude within 10 minutes. Mr. Cochin, if we have him ready, he may present.
Thank you. Thank you. Thank you for your time, and thank you for agreeing to take my presentation remotely. I say at the beginning, I speak as an American academic, a political philosopher, and historian of the United States, and not on behalf of my institution, Tel Aviv University, itself a recipient of Holocaust reparations. I was trained in political philosophy, that is to look for the questions not asked, and see asking those questions changes our thinking on the questions usually asked in public debate. My goal in the next few minutes is to shock you into thinking a bit differently about some very familiar questions. Now, the pressure for reparations from American slavery comes from 2 sides. First, from moral outrage. It is part of a legacy that in other respects and for other reasons, we Americans are not ashamed of but proud to claim, right? That is, as Americans, we participate and aim to perpetuate institutions, the union of the states, the Constitution, the free market, that a century and a half ago actively worked to hold innocent men, women, and children in wrongful slavery. Second, pressure for slavery reparations comes from the recognition of persistent caste-like inequality between the descendants of persons held as slaves in the United States and other Americans. As I wrote in 2018, summarizing other people's research, the descendants of American slaves live shorter lives than other Americans, are less likely to have stable families, are more likely to be victims of violence, have lower incomes, less wealth, and lower levels of educational attainment. As Americans, dedicated, as Lincoln said, to the proposition that all men are created equal, this persistent inequality outrages us. This outrage is all the worse because it is incoherent. It is incoherent because we do not have a current term or word that marks out the people whose unequal condition today outrages us. The relevant category is not a racial category. We do not feel the same obligation to mitigate inequalities toward Black immigrants and their descendants, even Black immigrants from other places outside the United States, where Black men, women, and children were held in legal slavery by whites or Europeans. The peoples whose relative deprivation outrages us are not an organized community or people separate from other Americans. We are not speaking of a nation or of what in political science is called an intentional community. We all know or should know the exchange from Jordan Peele's 2019 horror movie, Us, a film that is an allegory of the relation between privileged and less privileged Black Americans. What are you people? Asked father to Black upper middle class family Gabe Wilson of their newly emerged clone rivals and enemies. And the answer comes, we're Americans. The problem with reparations is to find some way of mitigating inequalities that distinguish some Americans from other Americans in order to atone for moral outrage that still stains the institutions that we Americans cherish and wish to continue. When we put the problem that way, we see that 2 frequently cited modern examples of reparations provide limited guidance in thinking about reparations for American slavery. In 1988, the United States government agreed to pay reparations to those Japanese Americans who were interned by the United States during World War II. Those payments were modest, almost token, $20,000 for each survivor of internment still alive in 1988, and were not intended to, nor could mitigate persistent inequalities. Why were the payments so modest? Partly, I think, because the kind of persistent inequalities that concern us regarding the descendants of persons held as slaves in the United States are simply not found in relation to Japanese Americans, whether we speak about those individuals who were interned, the generation of those interned, or their descendants. There's also the example of Holocaust reparations, which is cited in Ta-Nehisi Coates' well-known essay, The Case for Reparations. Those reparations were paid from one community to two other communities, from the German state to the Jewish community organized in various bodies, such as the World Jewish Congress and the Claims Conference, and from the German state to the state of Israel, the national state of the Jewish people. The whole point is to repair by compensation in money and goods the relation between one people and another, between Germans and Jews, and between the Federal Republic of Germany and the state of Israel, even when the recipients are or were individuals, and when their claim is calculated on the basis of individual deprivation by Nazi crime. This matters because the state of Israel could use the payments it received for the benefit of Jewish Israelis. It had a parliament, a government, and a bureaucracy to debate and decide how to use reparations for the common benefit of the Jewish people, the collective victim of Nazi outrages. For slavery reparations, the problem is within a single community, the American people, and there's an attempt to deal with the outrages that some Americans inflicted on other Americans through the American institutions that for other reasons and in other respects we esteem and wish to perpetuate. Unlike in the case of Holocaust reparations, reparations for American slavery, in whatever form it takes, will have to be worked out by the same institutions and for the same American people as both victims and perpetrators. Unlike in the case of reparations for Japanese Americans, also paid on behalf of Americans to Americans, the problem to be addressed by slavery reparations is not to symbolically to atone, but to respond to persistent inequalities, which reparations should do something visible and tangible to mitigate. What about affirmative action? Well, I was asked to be here today because I published an essay in 2018, The Whipped Cream Boys of Affirmative Action, arguing that affirmative action programs of the kind that exist today are not a suitable vehicle for mitigating the persistent inequality between the descendants of persons held as slaves in America and other Americans. First and most important, they haven't worked. In fact, those inequalities such as crime victimization are in important respects as bad, if not worse today in 2022 as they were in 1965, when President Johnson announced his affirmative action policy in a speech at Howard University. The failure of affirmative action programs is obscured because government media, think tanks, and universities use racial categories such as black and white to study inequality instead of gathering separate data on the descent of persons held as slaves in the United States. Second, because affirmative action policies are defined in racial terms, they are not an answer to the real problem. Reparations are for victims, and while it is true that slavery in America and everywhere else on the globe where slavery was practiced was racialized, in the United States of 2022, such programs as affirmative action that designate beneficiaries by race are not reaching those harmed by the persistent legacy of American slavery. In my view, California's response to the question of reparations should be to seek out programs that, in the light of more than half a century of modern experience, have some prospect of mitigating the relevant inequalities. Here, I think the best thing to focus on is education, and in particular, education at the K-12 level. Make it easier for the descendants of persons held in slavery in the United States who live in California to get a good school education. My authority is California economist Thomas Sowell, a descendant of persons held as slaves in the United States, born in 1930 in Gastonia, South Carolina, amid the last living memories of American slavery. As Thomas Sowell details in his 2020 book, Charter Schools and Their Enemies, the 2019 California charter school reform legislation goes the wrong way, making it harder for impoverished parents, and I would add, especially for impoverished parents descended from persons held in slavery in America, to ensure that their children are enrolled in schools that will teach them adequately. Rather, California need to make sure that every California child, and in particular every California child of descendants of persons held in slavery in the United States, is guaranteed a free K-12 education. Education does not mean time in the classroom chair between birth and prison or birth in the streets. Education must mean actual scholastic attainment that will give these children and all California children the skills and talents required for a fulfilled adult life. Charter schools and easy access to them, Sowell shows, are a vital part of such an education policy. Because of the importance of school for remedying inequalities, California should annul or obliterate other public policies that stand in the way of educating each California child and descendant of persons held in slavery in the United States. And I speak as a unionized teacher, well aware of the benefits of unionization for teachers, especially uncommitted, distracted, or incompetent teachers. At the post-secondary level, I think the state can do is identify and increase access to programs that pipeline students come to the classroom to rewarding careers. Such programs are often co-ops, where job placement is part of the curriculum and students work at their careers through their time in school. The state of California, in my view, should identify inequalities in access to those programs. The state should then formulate, apply, study, reformulate, and reapply policies to mitigate those inequalities in the state of California. Race is fundamental to understanding the history and legacy of American slavery. But thinking beyond racial categories is vital to formulating and implementing public policies that will mitigate the inequalities that are the legacy of American slavery. If the Civil War settled one thing, it made all of us Black and white Americans. Thus, it made the problem of repairing relations between the victims and perpetrators and perpetrating institutions a problem for all of us together as Americans. We Americans of 2022 want to find a policy response that will make it possible for us to go on together as Americans. Thank you.
Thank you, Professor Colchin. Our next expert witness is Professor Jennifer Mason McAward. Jennifer Mason McAward is an associate professor of law at Notre Dame Law School and the director of the Clow Institute for Civil and Human Rights at Notre Dame's Coe School of Global Affairs. She received her undergraduate degree summa cum laude from Notre Dame in 1994, majoring in government and international relations and minoring in theology. Following law school, Professor Mason McAward served as a law clerk for Judge Alex Kozinski on the United States Court of Appeals for the Ninth Circuit, and then for the United States Supreme Court Justice Sandra Day O'Connor. Her scholarship has explored the history of the Reconstruction Amendments and the scope of Congress's power to pass legislation to enforce the 13th Amendment. I'm extremely excited to have you, Professor Mason McAward, and you may begin your expert testimony when you're ready.
Thank you so much. It's an honor to speak with you all today. I hope that some of my work on 13th Amendment enforcement law will be of use as you continue to think through the appropriate role that the state of California can and should play in addressing racial disparities and inequities. Section 2 of the 13th Amendment gives Congress the power to enforce this article by appropriate legislation. And so the question that I've grappled with is what sorts of laws Congress can pass to enforce the ban on slavery and involuntary servitude. So Congress has been empowered to pass not just direct enforcement legislation banning, for example, human trafficking, but also to pass all laws necessary and proper for abolishing all badges and incidents of slavery. And that concept of badges and incidents of slavery, which appears in your own work as the task force, originated with the 1883 Supreme Court decision in the civil rights cases. And it's since taken on canonical status as the outer boundaries of Congress's 13th Amendment enforcement power. And my scholarship has considered the roles of Congress and the Supreme Court in addressing the badges and incidents of slavery. And I've tried to come up with a definition. Incident of slavery was a legal term of art that referred to legal aspects of the institution of slavery. And badges of slavery was a more malleable term that referred to the broader set of political, civil, and legal disadvantages imposed on slaves, former slaves, and free Black people. And so in determining what the badges and incidents of slavery are that Congress can regulate, I asked three questions. Whom can Congress protect, from what conduct, and by what actors? And in answering those questions, I looked at the historical record and considered structural separation of powers concerns. And ultimately, I concluded that badges and incidents of slavery have the following characteristics. First, they are policies or widespread practices that mirror a legal incident of slavery or infringe upon an aspect of liberty that was denied to slaves. Second, they're implemented by public or widespread private action. Third, they are aimed at disadvantaging African Americans or other populations that have been enslaved. And fourth, they point not remotely to a violation of Section 1 of the 13th Amendment. In other words, they pose an imminent threat to freedom or the ability to participate in the basic transactions of civil society. And the reason I included this final kind of causation element in my definition focused on kind of that idea of prophylactic legislation that incorporates these principles of separation of powers at the federal level. With the idea that we needed to have some kind of constraint on the legislature as well as a guide for effective judicial oversight. The important question here, though, is whether that same understanding should guide the exercise of California's own legislative power. and I am certainly not an expert on California law, but I do know that the California Constitution bans slavery and involuntary servitude and gives the California legislature plenary legislative authority to enforce that guarantee. And the law establishing this task force contemplates more than direct enforcement legislation, specifically laws that are aimed at the lingering negative effects of slavery. And in many ways, the focus of this task force's work maps onto my conceptualization of the badges and incidents of slavery. Our work especially appears to align on the questions of actors and conduct. The findings of this task force, which recognize that slavery and its aftermath were the product not just of law, but of private conduct and custom, is of course entirely accurate. Its correlate that remedies must also engage public law and private systemic conduct reflects an important operational insight that can serve as a guide for legislative efforts. One place where our work might diverge is on this question of whether the conduct that's being regulated must have some kind of threshold causative impact to be properly the subject of legislation. But as I said, the reason that I included that in my definition draws from concerns about separation of powers principles. And it's not clear to me that those same structural concerns operate identically in the context of state reparations laws and policies. While the interim report does frequently address the ongoing system-wide impacts of racially discriminatory policies, it doesn't argue that those impacts currently violate or threaten to violate the California Constitution's ban on slavery. And so the question I asked myself is whether this is a problem, and the answer may well be no, because of the nature of the plenary state legislative power, as well as distinct separation of powers analysis for purposes of constitutional law. And so I simply just note that and raise it as a question for your consideration. One place, however, where our analyses might diverge more meaningfully is the question of who can receive remedies or reparations. And I know that this task force has dedicated time and study to this question and come up with a definition regarding eligibility. As I understand it, however, there's still a racial component to the definition you're using. In other words, it still depends on race. An indigenous Californian, for example, whose ancestors were also enslaved, would not be eligible in the same way that a Black person would be. And so the proposal is under-inclusive in the sense that only some people whose lineage includes slavery are eligible for reparations, but not all. And so in the context of state reparations legislation, it is clear that the 14th Amendment's Equal Protection Clause will be applied to guide and evaluate any legislative efforts. And so while not all of the task force's preliminary recommendations are race conscious, some of them are. And those strike me as requiring further analysis to determine their viability. As you surely know, the Supreme Court applies strict scrutiny to all racial classifications, saying that strict scrutiny applies whether a classification is invidious or benign, and it requires a showing of a compelling governmental interest as well as narrow tailoring. In a series of decisions, the court has rejected the idea that government can use race-conscious action to remedy societal discrimination writ large, and has criticized that as an overbroad remedial interest. However, the court has said that remedying the present effects of the state's own past discriminatory conduct may be a compelling interest, as long as there's a strong basis in evidence to show that there has in fact been past discrimination and that remedial action is necessary. I raise this because, among other things, as you also surely know, there's an affirmative action case pending at the Supreme Court this coming term. And given the composition of the court and the view of at least some of its members highly skeptical to race-based classifications in general, I just wanted to recommend that you closely follow the court's arguments and its upcoming decision. Even if the court, however, stands by its position that remedying specific past governmental discrimination is a compelling state interest, there would still be a question of how the preliminary recommendations of this task force might satisfy strict scrutiny and be deemed narrowly tailored. And again, I would just raise that for you to consider as you move toward final recommendations. My final point draws from that, which is that an effective reparations initiative must be both implementable and implemented. And so even if you were to conclude that all of your proposals would withstand scrutiny, I just would think that you would also want to use as a criterion the likelihood of litigation. To what extent would something be likely to draw a legal challenge? Even if it wouldn't succeed, what would be the financial and logistical cost of advancing a particular recommendation versus the benefit of having it in place ultimately? And so that is where I will wrap up my testimony, but I just want to thank each of you. The knowledge and research that you have amassed is incredibly important, and it has been a real privilege to be a small part of the community that you're dialoguing with. So thank you so, so much.
Thank you, Professor Mason McAward. We had another witness lined up who would have been Mr. Alex Amaichi Ujugwa, who is a PhD at the University of Akwa in Nigeria, but he is no longer able to make it. And I'm looking back at the agenda, we have, that would place us actually, it's 2 o'clock right now. So we have 30 more minutes for this agenda item. Does anyone have any comments or questions for Professor Mason McAward, Professor Jonathan Bush, or Professor Cochin at this time? I also just want to apologize to our witnesses for the audio issues that we've been facing. I think that impacted a bit how much we internalize the information, but we tried our best. So thank you. Since we do have 30 extra minutes, we have Professor Jonathan Bush, Professor Cochin, and then Professor Mason McAward on the line. Does anyone have any comments or questions at this time? Because Member Holder, go ahead.
Hello? Doesn't sound like it's on. Okay. I just want to thank the panelists. I'm sorry that we have had some audio problems, but from what we were able to hear and glean, it's very comprehensive and gives us a lot of insight as we move forward. I did have a question specifically for Professor McAward regarding your 14th Amendment analysis and your equal protection analysis. I'm specifically thinking about guarantees of non-repetition, which is, I don't know if you have been listening to the international perspective on reparations and the scholars that have spoken about that today. But one of the important international conventions for a reparations program is ensuring that there are guarantees of non-repetition. And I wanted to get a sense from sort of a constitutional perspective, how that can be synthesized with the 14th Amendment and equal protection, because it's forward-looking, it's prospective. So you're not looking at present-day discrimination, you're almost looking at creating programs that safeguard against future prospective discrimination. And so from a constitutional perspective, and from a strict scrutiny lens, how do you think that would play out?
Thank you, Member Holder. And I note that we are both NYU Law School graduates, so it's a particular honor to speak with you.
Likewise.
It's interesting thinking about non-repetition guarantees. I think typically we would think about that as kind of injunctive relief that could get entered in the course of a lawsuit. And I think it's an excellent point to think about how that would play out in a more legislative context, to think about how programs can safeguard against backsliding. So my work has focused on kind of this idea of prophylactic legislation that can address something more than simply an actual constitutional violation in order to protect against future constitutional violations. And that strikes me as somewhat similar to what you're talking about. But the question then is, how would that play out if a kind of prophylactic type of law were to be passed and then challenged under the Equal Protection Clause? And I would I would have to think more about it. But I guess the concern that I would raise is, given this current court's deep skepticism toward any racial classifications, I just think that the law should be really as cleanly structured as it can be in order to try to avoid as much litigation as might arise from it. But I'd be happy to think through that more clearly and comprehensively at another point.
Thank you.
Is there any other comments or questions for our expert witnesses from the task force at this time? I want to thank Professor Bush, Professor Colchin, and Professor Mason McAward for your expert testimony. Everyone give them a round of applause. Thank you. Okay, so it is 2:00. Our next item on the agenda is break, which would have occurred at 2:30 to 2:45. So now I'm turning to the task force for any advice or counsel. Should we take a break now or move forward with the agenda, which would be plan for future meetings, including schedule, whether virtual, and subject matters to be addressed? All right. Move forward. Okay, so we're going to move forward with the next item on our agenda, which will be facilitated by the DOJ with comments from myself and Jovan Scott Lewis. Thank you.
Okay, are the slides able to be put up? We may need the extra time, so. Thank you very much. So in this agenda item, I plan to present to you a few slides about the remaining work combined with a follow-up on the discussion we had yesterday regarding advisory committees, and then leading into a plan for the future meetings schedule. So I'm sure you're reviewing those as you go. I will walk you through the slides. So slides 1 and 2 outline the remaining task force work. This work basically boils down to the work that was not covered in the interim report. So what this work includes, first and foremost, redressing the harms covered by each chapter of report 1 through specific remedies. I'll come back to that, but essentially in plain language, that is taking the issues that the experts, the economics expert team talked about yesterday, converting that into concrete recommendations and the hard numbers around what reparations amounts are and how those reparations should be delivered. Okay, I'm going to circle back and we'll talk about how we staff recommend that work be carried out between the task force through advisory committees, which I started talking about yesterday, the experts that are retained for this, and then ensuring that the task force is engaged at all decision points along the way. The second issue is somewhat dependent on the first issue, which is what other forms of other restitution and rehabilitation are warranted. This will be subject to the task force's evaluation essentially after you have resolved the reparations that are going to be tied to each of the existing chapters in the report. The next item, and this goes to the next page, number 5, is the elimination of racist laws and policies. We have a retained expert that is working on developing a compendium of all the racist laws in the state. We're working with them to work through how those are delineated, how they're categorized, and then there will be a recommendation pursuant to the statute from the task force about how those laws should be eliminated. The next area of work is on appropriate ways to educate the California public of the task force's findings. We talked about this a little bit yesterday. There's been some ideas around creating curriculum so that the task force report can serve as a basis for educating children of all ages up through college. We are, as you can see, recommending that the task force instruct the Department of Justice to retain an expert to work on this. And finally, the last thing is how and what form a formal apology should take. That is going to be something, obviously, that the task force will work through. So that is the remaining workload following what's set forth in AB 3121 that was not covered or addressed in the interim report. Does anybody have any questions about that?
I hope that we remember that we carry in our pockets, our personal possessions, AAA card. Whenever you need AAA after your car is broken down, they will always ask you, are you in a safe space? And we say yes or no. It's very obvious from the discussion, from the responses here. We are not in a safe space when it comes to acknowledging that the crime against the humanity of Black folks was wrong. But remember, AAA has 3 A's, and I would like to brown eyes those A's. The first A is to admit that you got a problem. Something's wrong. It appears to me that the low-hanging fruit is for us, as we go through our process concomitantly, push with this state under this present leadership to admit, give an apology. We can get running with that. Number 2, there is atonement. That's where actual reparations comes in. You have a plan, like it was for that little man, Zacchaeus in the Bible. He told Jesus, the prophet of Nazareth, that if I wronged anyone, I'm going to pay back 4-fold. That's reparations. And the final A is action. Action. And I think on yesterday, we got the action plan moving to make sure that every member of the Assembly and the Senate has a copy of this report, and including the governor. And that will get us on the road toward some action And then that's when all of us in the community were really upset about this thing. You get involved too with some action. And that means getting all the sectors of our African-American community and our allies to start respectfully, peacefully, sensibly, factually, asking them to support reparations in this state.
Thank you very much for that. I certainly appreciate that very much. Did you have a question, John? Oh, okay. So are there any other questions or comments about the work that is remaining to be done under the statute? Okay. So we'll proceed to the third slide. So you all asked yesterday for some proposals around how this work would be done in a way that engages the members of the task force and ensures that the task force is working through the issues. We discussed internally and worked through a concept for the creation of advisory committees. As I alluded to yesterday, we talked about this a little bit, how that would look. And there are a few items that you'll need to vote on to put in action. But our recommendation is, in order to engage the task force directly in the work of working through these issues and making the decisions in a way that you could be working directly with us, and then we can bring items back to the task force for votes, rather than waiting for the length of time between meetings for the DOJ to be working on and then come back each time, is to have 1 or 2 advisory committees that would take on each of the 5 topics delineated by the experts in their presentation yesterday as atrocities. Those include unjust property takings by eminent domain, devaluation of Black businesses, housing discrimination and houselessness, disproportionate Black mass incarceration and over-policing, health harms, and then I have added into this list education, because there was an extensive discussion yesterday about the need to really prioritize education. And so our recommendation is to create either 1 advisory committee to work with the experts in the Department of Justice to work through the actual reparations framework for all of those items, or to divide that work into 2 different advisory committees. And I've presented here a proposed way in which I think logically those 6 items can be grouped. So that's going to be 1 or 2 advisory committees. And those advisory committees are going to need to answer the 5 questions that were laid out. First thing is to answer the 5 questions that were laid out by the experts yesterday, which is the questions that they need answered in order to calculate what reparations looks like, what the amounts are, who would be getting the reparations, what are the damages. And so that would essentially be the first work of the advisory committees. And then there will be, as we discussed in the scope of work, a little bit of back and forth between the advisory committee members and the experts, with the Department of Justice attorneys facilitating that conversation and drafting up the proposals. Eventually, we'll get to the future meetings plan, and eventually the role will be the advisory committee members will then be presenting this information back in future task force meetings, presenting the proposals along with the experts, who will provide the factual data-based case for reparations on each of those items. So that's 1 set of advisory committees. And then if we go to the next page, there's 2 additional advisory committees. 1 would be an advisory committee that would essentially work on everything else, all the other chapters that are not sort of taken up with those 6 atrocity areas. Those include enslavement, racial terror, political disenfranchisement, pathologizing the Black family, control over creative, cultural, and intellectual life, and the wealth gap. And the idea here is that those are, as we heard from the experts, not necessarily areas that can be boiled down to an amount of damages or an amount of compensation, but there are going to be a number of policy recommendations that we can leverage the preliminary recommendations that were included in the interim report into some final general policy recommendations on each of those, which could be turned into legislative proposals or something like that, and following the publication of the final report. And then the second advisory committee that we're recommending are what I've grouped together as remaining issues. And that includes how we eliminate racist laws and policies, what are appropriate ways to educate the California public on the task force's findings, and how and what form a formal apology should take. And each of those are rooted in one of the components of AB 3121. I'm trying to make sure that we check every single one of those boxes in that statute. You'll also see here a reminder of where the task force stands with regard to existing or previous advisory committees. We have the Communications Advisory Committee, which is Chair Moore and Member Grills, the Subpoena and Survey Advisory Committee, which are members Tamaki and Holder, the designee for the Bunch Center contract, which is Member Grills, and then the Economic Experts Advisory Committee, which is essentially, as of yesterday, really completed the work in terms of bringing on the economics expert team, getting the contract going, figuring out the scope of work. For all intents and purposes, that work is completed. That was Chair Moore and Member Lewis. And then the report finalization advisory committee, which is sort of on hiatus until we get to report 2. I'm now realizing we left one thing off, which is Chair Moore and Member Lewis work on the meeting ahead schedule and future meetings. So that's part of that too. I'm going to stop there. Are there any questions about the staff recommendations? It's a lot. It's a lot. We're certainly, the second part of this process is more work intensive, I think, for the members of the task force, and less focus maybe on the testimony and things like that. Are there any questions?
Yeah. I mean, Camila, you have anything you want to say first, or yeah? Okay.
Your mic's not.
Can you not hear me?
Now I can.
Oh, you can? So thank you for the recommendations. I think, I think I understand, I understand the kind of the argument for the economic expert, Chair Moore and myself, that stage of the work being done. But I'm not quite in, in agreement that, the role of us as a advisory committee is done. I think there's a way to, in my view, there is let's make sure I'm understanding myself here. Okay. So on the first page, you have, the 2 categories that comprise about 3 areas each. This is the previous slide. So the staff recommendation, the first, yeah, that one. So I'm in total agreement that I think there should be an advisory committee for that first cluster, an advisory committee for that second cluster. What I don't necessarily agree with is that the role of those advisory committees is actually to answer those 5 questions. I think the role of those advisory committees should be to further probe those areas. My concern is that there really is like a tick box approach to some of these things, and we're really not getting into a certain level of depth of what we're talking about here. So for example, let's just look at those first 2 clusters. Some of the kinds of questions that advisory committee could work with the economic experts on is saying, well, let's, how can we identify all complicit parties in these acts? These aren't really questions we've been really asked, right? How do we think about the variances and calculations between one activity and another? So these are the kinds of things that I think an advisory committee should actually work with the economic experts on. I think a third advisory committee, which could perhaps be, Chair Moore and myself continuing in our current role, to actually, work on those 5 questions, right? The kind of parameters, that kind of thing, because that would also have to be looked at from, I think, someone of a higher scope, to kind of think about, well, how do we think about qualification, damage timeframes across all of these different areas? So I think, I don't want to call it a hybrid approach, but I do want to make sure that we are paying significant attention to and devoting adequate time to a kind of deeper analysis and probing of these different areas. And I don't think that a model that's proposed accomplishes that. So I just wanted to kind of put that out there, as an alternative to this. And I think, just jumping ahead quickly, I have a question about the hearing schedule. I know we haven't gotten there yet, but that's not the hearing schedule that is in the agenda materials or that Chair Moore and I submitted. So I'm not sure, what this one is. And the reason why I asked that is because the proposed hearing schedules that Chair Moore and I came up with actually did, I think, in the detailed manner, agendize some of the remaining responsibilities or issues. And so I just want to make sure that I understand what this proposed hearing schedule is meant to do in relationship to that, because I think that would have some consequence on how we portion out some of the work.
Yes, that's correct. I don't know, Chair Moore, did you want to say something or not? Okay. Yeah, you're correct. You're absolutely correct. So first and foremost, I'll talk about the hearing schedule.
Yeah.
We haven't gotten there yet, but I'll talk about that. So that is correct. This is a sort of a staff recommendation hearing schedule. Your hearing schedule is still
Right.
in there.
Okay.
I essentially, one of the things I was attempting to do was both in response to some of the discussion yesterday about the timelines and about the contents and how we would be approaching the different issues in the report that would be published by June 30th, 2023, as well as pending a vote of the task force on whether to be in person or remote and whether to have it in the locations laid out, as combined with the need to have these advisory committees working on the substance, trying to figure out a way, frankly, where we could manage getting outlines to you all on sort of the comprehensive issues and then going through the drafting process again on the comprehensive issues as we go through. Part of this is why I recommended 2 task forces, is to sort of spread out the workload so that we could kind of be going on all cylinders on all of it. So we'll come back to the future meeting schedules. The second point you raised, which is the 5 questions. And I think you're right. That is another way that this could work, and that's fine. This is our recommendation. But the idea was definitely not that the advisory committees are only answering these 5 questions. I don't know if that's what you thought I was suggesting, but that's definitely not. I think you're right. And that's one of the reasons why we're recommending that they be split up and it not be one advisory committee doing all 6. Because I think there will need to be that very deep dive. And again, as we talked about with the advisory committees under the Bagley-Keene Act, the advisory committees are working with us, and it'll eventually come back to the entire task force. And so back to the future meeting schedule, I wanted to make sure that we had an opportunity for something on each of these items to come back to the task force to weigh in, to make sure the task force is invested and on board with what each of the advisory committees is developing along the way. So that also necessitated a little bit of a switch in terms of accommodating that time, because that's going to be pretty time consuming. If you think back to when we went through the drafts of the original report and the outlines of the original report, going through all of those different topics is going to consume quite a bit of time in the meeting.
Right.
So I hope that answers your question. And obviously, this is going to be, I'll come back and say what I need votes on before we finish this module. But that's certainly another way to go if you want to have the existing expert advisory committee of you and Chair Moore handling these 5 questions essentially for all of the issues. That's certainly another way to go. The only complicating factor there is that 2 advisory committees can't communicate. So you'll have to resolve that issue in a meeting where it's discussed amongst the whole the whole task force, and then each of the advisory committees will proceed based on whatever the outcome is of a vote of the entire task force on the answers to these 5 questions. So we would need to probably, frankly, agendize the answers to the 5 questions for whatever the next meeting is.
Vice Chair Brown, you're recognized.
Madam Chair, I would like to invite us to consider starting at page 5 and going forward. Why? Time is of the essence. And we made a commitment as a task force to do a job. And what we've heard here is nothing new. We heard it from day one. And we can end up with information indigestion. And actually, I think we should look at the schedule and see if it's realistic. And in no way become guilty of the allegation that's been made that we haven't heard everybody. We have a schedule. And my appeal as vice chair is that we would do all we can as humanly possible to move forward. Why family? Let's face the reality of the present political climate in this nation and this state, and I would say even worldwide, with this populist movement stuff. And put your hand up, feel it. And we need to, as Benjamin May said, he or she who's behind in the race of life is going to stay behind. Yes, you better run faster to catch up. It's time for us to run faster and catch up. Or else we're going to be left behind. And after the political bombshell comes, we still will not have made much traction toward getting our just due as Black folk.
Okay, and I'm making an appeal as chair, since we are ahead of schedule, that we actually take advantage of our break. So it's 2:30 and the break is from 2:30 to 2:45. And during this break, I think it would be good just for us to review the material a bit, kind of internalize it a bit. And then we can come back and see how task force members feel about what's on the page, and if there's any alternatives, we can discuss that as well. How does that sound? Okay, so we'll take our break since we are ahead of schedule, and we'll resume at 2:45.
Okay, family, thank you guys so much for hanging in there. They're on break. As we see, we will keep our ears perked up for when they return. Let's see what my co-hosts have to say about it in the chat. If you'd like to chat and be a part of the co-host, you have to join us in ScrewTube at the Reparationist Perspective. Please be sure to like, share, subscribe, turn on your notifications. And if you feel so compelled to bless the broadcast, do that as well. That way you guys can support my voice in this space as a part of the new Black media. I am the little engine that could. You know, I have a modest 1,100 subs. But I am managing Freedman life. My daughter is now off to college. And this advocacy work. So, I come over here when I can. When I have a window, I try not to be so angry when I'm over here, although there's a lot to be upset about, given the current state of American freedmen. Speaking of which, I do want to touch on what the white lawyer was talking about and why it's imperative that we start identifying as our ethnic group American freedmen. She's absolutely right. Even though we cornered this thing off as lineage based, African American includes the Africans who descend from our slave traders who are in this country double dipping, who are in this country able to take advantage of all of our affirmative action and all of our civil rights because of skin color. You know that saying, all skin folk ain't kin folk? That's absolutely true. So out here, we did a great turn with delineating and disaggregating the data to include African American, descendant of U.S. chattel slavery, or non-descendant of U.S. chattel slavery. Well, that doesn't stop African Americans from marking off the box that they descend as U.S. chattel slavery to take a back door. When we start to go back to quotas in the public sector anyway, that's what they're working on first and foremost, getting an assessment of the percentage of us who actually descend from U.S. chattel slavery. What's to keep African Americans who descend from our slave traders from marking the box that they descend from U.S. chattel slavery to stay gainfully employed at the state, city, and county jobs? Who's to say they won't just do that? And if you've got the immigrants and whites in charge, who's to say that won't be allowed? You follow what I'm telling you? So they're going to have to do something beyond race. Black and African American are race. We must start identifying as American freedmen. It doesn't matter what you identify as, amongst your set, whatever set you rep. If you rep B1 or ADOX or ADOS or hashtag ADOS or FBA, BADOX, it don't matter. You bleed descendant of U.S. chattel slavery, and only American freedmen is constitutional. I've got the book right here. The American Freedmen, March 1868. Y'all should get this book. I may have to cover this book on one of my broadcasts, but it's dealing with the amendments that deal with us as a specific group. This is by the American Freedmen's Union Commission. So you guys have got to get this book. And yeah, so my thing is, this is where, we can run into trouble. And this is why I say Black immigrants are so freaking greedy, coming up into our task force hearings, demanding that we undo what's already been done, because they want to attach to whatever goodies we've got coming. So that keeps us tethered to the bottom caste. If we're enriched 500K and we take that 500K and we grow it into 5 million, and we get all the things that I mentioned earlier, plus I forgot to include a couple items, then immigrants will have to trade places with American freedmen, which they should have to anyway. There ain't no way in the world that immigrants should be outpacing American freedmen when our ancestors built the wealth that they eat from and benefit from. But here we are in last place, like Dr. Claude Anderson promised we would be if we didn't neutralize immigration. But no, we kept showing up to the polls, voting blue no matter who, to our own people's peril and replacement. So just so you know, that white attorney was right. I can't recall her name, but we may still have a fight on our hands because we identify as African American, which is race. And we've been fighting, me and a few of my grassroots on the East Coast, we've been fighting for our American freedmen ethnicity. And we're going to continue to fight that on the federal level in the upcoming OMB sessions, okay? So yeah, let me see. There were a couple of items that I forgot to mention on my list that I'm going to add and email the task force, but specifically reach out to Chair Moore since I've got my thumb on the pulse of her. Beautiful lady, inside and out. Chair Moore is such, oh my God. All of us are making history, but she's really going to have a special place the way she manages these task force hearings. I just love her so. But yeah, so I'm going to email her a couple of things directly. First of all, I forgot to include that each and every American freedman received an electric SUV, okay, or hybrid, whatever you want to call it, because those cars are around $50,000 to $100,000, and California's on that bull about solar powered electric cars. But who in the world making a median income of $40,000, if you're blessed to have a job out here, can afford an electric car between $50,000 and $100,000? So that was one of the things I said that I'm going to add to my list. And let me scroll down to my comments. I'm going to read your comments momentarily. After I share this one last thing, I'll go through and see what you guys had to say and share it on the screen. They can use the 5. Oh, I was talking about direct deposits like they did the COVID debt relief with more of our reparations. That COVID debt relief was another white and immigrant transfer. And that's our reparations at work to benefit everyone but us. Let's see here. I was correcting Dr. Brown, who said African American. You can understand that that's your race, but you must identify as your ethnicity so that you won't get canceled in the Supreme Courts because of race. You see, that's what they've done. They've given us race as a social construct and made sure we couldn't weaponize it against them when they exercise discrimination against us based on racism. That's what I mean by the Democrats creating the problems and then wanting the freedmen vote to be the solution to our own people's peril. Okay, so American freedmen. Oh, I was talking about, I forgot to mention that we need American freedmen teachers. It's not just education. Like I said in my earlier comments, a college degree does not guarantee you a career with a California salary, okay? So let's be clear that that's due in large part very much symbolism, although it should be free. When we're dealing with education, we have to undo the miseducation in the public school sector that our tax dollars pay for, right? So I said I want American freedmen schools with American freedmen teachers and American freedmen students. And I want them to be taught the history. That 500-page history, I want to do like that Asian lady suggested. She suggested that something about breaking up the chapters. I would like those chapters inherent in that 500-page report to be broken up like an encyclopedia set, and that the kids starting with kindergarten, you can do, grade level kind of books to reach the attention of the peer group you're speaking to. But I believe that not only do our American freedmen babies with our American freedmen teachers and our American freedmen schools need to be taught from this 500-page report, it should be mandatory for all the immigrants and white folks here in the state of California, since y'all call yourself so liberal. This should be standard in every public school. That 500-page report broken down into bite-sized morsels vis-a-vis a chapter, a book. That's how this thing, and they need to be tested, and you should have to pass these tests before you can graduate high school, and you need to start teaching it from the time they're kindergartners. Like I said, make the adjustments. I know our babies can't understand the 500-page report that you and I can understand. And hell, even a lot of the adults that I'm dealing with in my race book, reading comprehension is a challenge, okay? I could say X, Y, and Z, and they come back and say, you said X, Y, and Z. You don't comprehend. Now, comprehension is taught in the second grade, or that's when they start to discover. That's what happened with my daughter. They realized this girl can read like a whiz. She knows how to pause for commas and semicolons and carry it on, but she has no comprehension. She can read, but she don't understand what she's reading. Okay? So trust me when I tell you, that is a challenge even for most adults, okay? Not most, a lot. Let's just put it like that. So that's another thing I'm going to add, and I'm going to send that to the lovely Chair Moore along with the task force. I just don't believe, see, I show up for public comments and try to cram, a whole entire year's worth of feelings about it into 3 minutes. I show up because I don't believe they are circulating our emails. And I don't believe they're reading them because they're not circulating them. So I don't take no chances. I try to show up early in the queue so I can have my say. And I just consider it a blessing from God, especially when I'm not there and present. But I think about it today, family. If I had showed up today, you saw how they had to cut them off, right? And they ain't gone back to them people yet. If I had shown up today, it was cut off. It couldn't speak my truth live on that microphone. Woo-wee. I'd have been hotter than fish grease. I was already over here quaking in my boots as they said they were going to take only 3 more speakers. I was praying to the ancestors that I was one of them, so I was chosen. Praise be to God. Okay, but listen, it's hit or miss, and they have skipped right over me on maybe a couple of occasions over the past year. Okay. So yes, those are the 2 things I want to add. And let me see what y'all got to say. I think, they're about to come back. Never give up. Fight, fight. I can see it coming. I can dream it. I can feel it. Come through, Gwen. There's a lot of motivation in here by the sisters that are co-hosting. What is the name of what book, my love? Did I miss a book? Oh, the name of the book is called The American Freedman. March 1868. Now, I have volume 2, so now this is a part of Forgotten Books. If you want to check it out, you can go to Amazon. That's where I got this copy from the vendor, Forgotten Books. It's called The American Freedman, March, 1868. And then it's a part of the American Freedmen Union Commission. And it deals with our Constitution. Well, let me see here. I don't have my Walmart readers on. And this print is very tiny. But I'm going to try to find a pair of spectacles. Let's see here. Where are my glasses? Now, y'all know I done bought 10 pair of these glasses and can never put my hands on them when I need them. Yeah, this is it's a very thin book. It's not many pages, but the print is super fine, y'all. Let me get my glasses. Hold on. Okay. Now, before I forget, I want to congratulate Gwen. She got a county job. Now, you know the county jobs comes with pensions. Okay? So you guys want to start looking here in California for those good government jobs in the public sector. She's got a nice county position. You can go for the state or the city jobs too. You must do it, especially now that we've got data disaggregation. That might help us. So let's see. So this is dealing with the American Freedmen's Union Commission. And like I said, the print is very small, but it is so important to have these books in your library. See, I'm still an old school girl, you know. I love the books. You should see my home. It looks like a whole library. Now, do I have time to read all of these books? No, I do not, but they make me feel smart, okay? I've read a lot of these books, but I'm looking forward to retiring so that I can sit up and read to my heart's content on any exotic island that I choose and just immerse myself. It's so rich. You can still put this by your bedside and read a couple pages a day. That's another thing you can do instead of turning on the television, the live vision, okay? Okay, so this says the American Freedmen example. This is fine, like the Constitution, y'all, but it's dealing with us. It is all about us. Okay, let's read the object. The object of this commission is the relief, education, and elevation of the freedmen of the United States, and to aid and cooperate with the people of the South without distinction of race or color in the improvement of their condition upon the basis of industry, education, freedom, and Christian morality. No school or depot of supplies shall be maintained, from the benefits of which any shall be excluded because of color. Article 2 of the Constitution. So this is Constitution, and it's small and it's tiny, but this is what this is. It's dealing with us, family. Address 30 Vesey Street or P.O. Box 5733 is at the top. New York, March 1868. And this is volume 2, number 12. So the journal is published at the central organ of the Freedmen's Union Commission for the benefit of the branches and the information of all who are interested in the work of education in the South. Communications should be addressed to the General Secretary, Reverend Lyman Abbott, 30 Vesey Street in New York City. So, honey, this is rich to put your hand on these pages, you know, that were crafted all the way back in 1868. And it's a small book. It's not very many pages, but the print is really small. You might need a magnifying glass or your Walgreens readers, okay? So let's see. So yeah, you can get that book. The handler just found out that the task force member challenging him can read. Y'all keep it lit up in here. It's so funny. Oh my God. So let's go back. So congratulations, Gwen. Thank you for, okay. Email sent. Okay, Yaira, my LBC sister. Well, definitely I'll reach back to you so we can make a connection. I'm here for my reparations for real, she says. I dreamed I had gotten my reparations. I bought me a business and a brand new home. I was living finally. Amen. Lineage definitely matters, Ivy Dreams. Okay, Danielle says, at the rep prospect, I sent you a DM on FB of that Professor Bush. His experience, involvement, and knowledge on global reparations is exemplary. Great resource for all the task forces. Thank you, Danielle. Yes, yes, yes. You guys want to send me anything, please, please, please. Well, Danielle is on my race book. So if you're not on my race book, you can email me. I'm very selective about who I allow as friends over there because, honey, my last page, my very first page back in November 2019, well, that particular page was Angela Nirvana. And honey child, Racebook shut that all the way down. Do you hear me? 5,000 subs. That's when I was streaming live mostly to Racebook. So never again. Now it's a private page. And if you want access to it, you have to Gmail me at therepperspect@gmail.com. It's scrolling in the bar below. Yes, family. You have to understand. That's awesome, says Danielle to Gwen. You were finally feeling how it feels to be allowed to be a full American. Yes, Danielle. And understand, as a metaphysician, which is what I am, okay? I'm into metaphysics. I am a New Thought. I attend a New Thought Bible-based church, but we are metaphysicians. And we understand that thoughts are things, family. You know, like how these rappers are, turning up dead everywhere you turn. Look at what they're singing about. There's power in your spoken word. Your word shall not return unto you void, but shall accomplish whereunto you send it. So if you've just got a diet of death and destruction and denigration of your own people, then by your words, you are dead. And you are only amongst the walking dead until someone finally takes you out. That's how that works. You are your thoughts. Your feelings make your thoughts manifest. That's the thing. Your feelings out of the heart of man are the issues or the advantages or the manifestations of life. Okay? So do know that as the image likeness of God, you've got mastery, power, dominion, and authority over everything. Your thoughts, your feelings, and your words don't control you. You control it. And when your thoughts and your feelings and your words, especially your feelings, are aligned with what you do want, and you focus on what you do want, then you get to benefit from that manifestation. But if you focus on anxiety, worry, doubt, anger, frustration, you get what you focus on. What you focus on expands. So, Gwen, you are absolutely right to start already making plans for your reparations. You are absolutely right to do it because it is through your words, through your creative vision, through all of those things that it will be made manifest. And don't be attached to how the money shows up to do that. You don't necessarily have to wait on reparations to manifest your dream home, to manifest your dream business. Okay? You can say reparations are something greater and have something come into your experience far more immediate. It's not hocus pocus, family. Your thoughts are your connecting link to your inner Christ. Your thoughts. That's where you ideate. That's where you create from. Your thoughts and your feelings make it manifest. Because you can't say, I think we're going to get, you can't think reparations and not sit in the silence and feel reparations and feel how you're going to apply that when it or something greater comes your way. Because a feeling gets the prize. You can think all day long, I'm going to be a billionaire. But if you don't really feel like you're going to be a billionaire, you're not going to get to be a billionaire because you don't feel it. You're not sitting in the silence and ideating from the space of your inner Christ to determine what that looks like. You got to have some place for it to go. All right? So hold on, y'all. Let me refresh the page. I can't believe they ain't back yet. Well, they ain't back yet, so I can continue to teach my metaphysics. That's coming to a broadcast near you. I'm going to be branching out and doing, God has put in about 10 to 12 shows within me. And I've only been focused on this one particular broadcast. But I'm going to be branching out for those of you who want more metaphysics, for those of you who want to know how to manifest your best life right now. When I was living in New York, I started studying visioning with Ian Van Zandt. And I said, I want to live on the ocean. I want to wake up to the water every day. And lo and behold, about 10 years later, after studying creative visualization with Iyanla, I was living on the ocean front. My baby was 8 weeks old at the time when we moved into our apartment on the beach here in California. You see, all because I studied visioning and I used my inner Christ power to make it manifest. I sat in the feeling nature of that. You must sit in the feeling nature. You must dream, and you can't put limits on what your inner Christ can manifest for you. You know, you can have what you believe you can have. If you put limitations, that's on you. You can take baby steps. Get to know your inner Christ. The way I started, I would ask things like, what do you want to wear today, beloved? Boom, the whole outfit with the accessories and the purse and the shoes would come to fore. So I started small so I could hear that still small voice within me and adhere to it. So that's what happened, and that's how me and my daughter ended up on the ocean. Because I created a vision and I made it plain, and I didn't put limitations on what God could do. So when I was done with that, I visioned for home ownership. It didn't take long. We were over there for 3 years. Within 3 years, I was purchasing my first condo, a 10-minute walk to the beach. It wasn't on the waterfront, but it's a 10-minute walk to the beach. That's because I used my thoughts, my words, my vision, my feelings, and it was definitive for me. I determined then and there, my mind was made up. I'm not going to rent anymore. And when I had a made up mind about that, the house manifested 3 years later. I didn't have a perfect credit score. Okay. I didn't have money saved up. I was earning about $120,000 a year, but I didn't have no savings. The more I make, the more I spend. So I didn't have a bunch of money saved up. I refused to borrow against my 401k. And I had someone that was a metaphysician that told me, she was a realtor. She had the unmitigated gall to tell me, nobody's ever going to sell you a house. Your credit score is a low 600. You don't have 10% down. You don't have savings. Okay. You're unwilling to borrow against your retirement. It's not going to happen. She attended the same church as me. And I was strong enough in my principles to go on over to Keller Williams and speak with a young gentleman who wanted some business. He wanted to sell me my first home. And I just went right on past what she had to say about it. He took me on as his client and managed to procure 100% financing. And when I closed, Bank of America was cutting me a check for $157.86. Or it might be the other way around, $156.87. And I didn't have to pay a mortgage for 2 months. Why? Because I wasn't listening to stupid people who think they know more than me about my inner Christ and what my God told me to go and do. Okay? You got to tune these stupid people out. When you're dealing with reparations, you can't listen to stupid people who are negative. Now, I wouldn't be doing this work if God and the ancestors didn't assign me to this work. I tried to run from this work, but it won't let me sleep because I see the peril of my people when I don't do the work, okay? So I can't sit up here and listen to the negative Nancys and the negative Neds talk about what can't happen when I see God's miracles all around me all the time. All the time. God has made folks show me favor that hate my blackness. Because God will make an enemy of your footstool, will make a footstool of your enemies. Let me refresh the screen, see if they back. Lord have mercy. No, they ain't back yet, so I'm going to keep talking. Apparently, this is what y'all supposed to hear on this break. I allow the ancestors and God to use me, okay? My inner Christ, when they have something to say to the people, and it manifests organically in the way that it has, then I'm going to talk to y'all in the way that the ancestors and God need me to show up. So, yeah, while we're on this break, okay? So do understand that when God brings it through you, when God gives it to you in the form of an idea, it's up to you to think right about it, to feel right about it, and to act right about it, and to react right about it for it to manifest. Okay? I don't know if you guys know Reverend Della Reese, the late Reverend Della Reese, Patricia Early-Lett. She was in Harlem Nights. She had a whole music career, whole acting career. Her latest series that before she transitioned was Touched by an Angel. Well, she was my minister. I don't know how many of you know that she had a church for over 30 years. Okay. She was my minister here in California. She manifested Touched by an Angel. She learned metaphysics from the late, great Johnny Coleman out of Christ Universal Temple in Chicago on the South Side. She learned how to speak, how to think, how to feel, how to act, and how to react to manifest Touched by an Angel. And I think they had about 8 or 10 series. Honey, I used to go up to her house in Bel Air and study with her. I used to go to the parties up in the hills of Bel Air. Hers was at the tippy top of the hill, overlooking everything. Because she thought right about it. She felt right about it. She spoke right about it. She acted right about it. She reacted right about it. She manifested an amazing career and an amazing church and an amazing home in Bel Air. Okay. And you know what was so bizarre, the way I was turned on to metaphysics? Do you guys remember the actress Kalita Smith from the Bernie Mac show? Well, she and I got our start in the performance arts way back in the Gap. We had our first stage play in David Talbert's Tell It Like It Is. And fast forward, when I left the tour, I went to New York. She came to LA. I went to New York because I wanted to be more than a Chitlin Circuit actress. So I studied. I studied the classics with the Moscow Art Theater School on Harvard's campus, and I studied Shakespeare with the London Classical Theater School. Well, one day I was over at the Public Theater where Denzel was starring as Othello, and who do I run into? Kalita Smith. It was rich. We hugged, we laughed, we went out to the after parties, and we got to talking. And Kalina started talking about having just manifested the Bernie Mac show. And I thought to myself, what do you mean by manifested the Bernie Mac show? And she started talking to me about this church that taught her how to think, how to feel, how to speak, how to act, how to react. She never told me it was Della Reese's church. She just talked about these principles that she learned, these Bible-based New Thought principles, and how she applied it and how it manifested the Bernie Mac show. And so fast forward, I move out here and I'm looking for church homes. And around November 03, I find Della's church. Well, I had been going there a couple years, and then one day I look up, here's Kalina at the church. And when we saw each other, we just fell out laughing. She was like, oh my God, you found the church that taught me the principles to manifest the Bernie Mac show. I never told you it was this church. We just fell out laughing and hugged. It had a great, great reunion in that moment. So yeah, there's lots of artists that are metaphysicians. Maya Angelou. It was the late, great Maya Angelou, metaphysician. She taught Oprah. That's why you see Oprah turn into a lot of metaphysical kind of authors and things of this nature. They're teaching you how to think, how to feel, how to speak, how to act, and how to react. So that's why it's futile to get upset with these tethers coming up in here trying to undo what has already been done. Everything is in divine order. That's what I wanted to reach through the phone and tell the people at the live today. Don't get flustered. Don't let these people, these disruptors, these agents of chaos come up in here and disrupt the calm peace of your soul. I have to tell myself that often, okay? Oh. I have to tell myself that often. Don't allow anyone or anything to disrupt the calm peace of my soul. And you also must be the gatekeeper. You must be the gatekeeper of what you allow into your kingdom, okay? Your queendom. That's your head. That's where your heaven is. That's where your pineal gland is, right in the middle. Right in the middle is your third eye, which is your first eye, okay? You don't want to just allow anything in there like these diabolical rap lyrics, these diabolical things that are on TV and in the movies, just debauchery. Like I will never watch that Dahmer movie on Netflix. That's diabolical. It's cannibalism, and it's an atrocity leveled at American freedmen. Poor American freedmen were victims of that animal. I will never let that into my consciousness. And you guys also need to stop having a diet of these state-sanctioned executions. Don't sit up there and watch that kind of stuff. Don't. It'll depress you. And God knows only what else it can do to your mental. You must keep the vision for the things you want. Don't live in the things you don't want. Don't do it to yourself. And teach your children how to think, how to feel, how to speak, how to act, and how to react. You must teach them that they are in control. They are the boss, but they got to take control. It don't happen just on autopilot. You got to take control, and you got to kill those negative thoughts and kill negative people. Not literally, but you got to get them out your life. You must. You are the thinker that thinks the thoughts that creates the things. Never forget it. That's why I tell you when I pray the covering of protection over you, that you're the face of God, the voice of God, the body temple of the Spirit of the living God. Because you've got all the mastery, power, dominion, and authority over everything. But if you don't use it, then I guess you don't. but it don't mean you ain't born with it. How do you think people rise up out of their circumstances? The only sponsor we got is our inner Christ. So you better get to know it and rely on it and it alone. So let me move down because I think I'm all talked out on that subject. I cannot believe the liberties they're taking right now. We're on 45 minutes of a break. Now, I'm going to give them a little bit more time to come back. Otherwise, I'm going to shut this down and get on with my day. I got a manicure, pedicure schedule. I got to go pick up some things from Amazon. I got to get some gas in my car. I got to get ready for church service on tomorrow. And I've got to get ready for my Chicago style stepping class. I got things to do. I'm not hanging out over here all day. So I'll give them a few more minutes, but otherwise, I'm gonna pray us out. Gwen XOXO, a full citizen of a first world nation. All of our prosperous communities were burned down. You're right, Ivy Dreams. Gwen is still luxuriating in the feeling. Yes, Lord, I can taste it. I can feel it. I'm finally free. Honey, the feeling gets the prize, baby doll. Freedmen are educated and we are still poor. Oh, here they are, y'all.
So we'll resume now. I need everyone to quiet down so we can resume our agenda. And I'll turn to Parliamentarian Johnson so that we can establish a quorum.
Yes, thank you, Madam Chair. I will begin calling the roll with the chair. Chair Moore.
Present.
Vice Chair Brown.
Present.
Member Bradford.
Here.
Member Grills. Here. Member Grills is present. Member Holder.
Here.
Member Holder is present. Member Jones Sawyer. Member Jones Sawyer is absent. Member Lewis.
Here.
Member Lewis is present. Member Montgomery Stepp.
Here.
Member Montgomery Stepp is present. And Member Tamaki.
Here.
Member Tamaki is present. Madam Chair, there are 9 task force members and the number needed for a quorum is 5. The number present is 8. Madam Chair, a quorum has been reestablished.
Thank you, Parliamentarian Johnson. Now that a quorum has been reestablished, we will resume our agenda item, which is number 20, discussion and potential action item, plan for future meetings, including schedule, whether virtual, and subject matters to be addressed. Before me and Member Jovan Scott Lewis share our thoughts around this agenda item, I just wanted to check in with my fellow task force members to see if you all had any break. Totally fine if no thoughts right now, but just wanted to open space for that opportunity. Member Montgomery, you're recognized.
Thank you, Moore. I have a few thoughts, and I don't think, this may be a little bit premature based on what you and Member Scott Lewis will share, but I did have a couple of thoughts. One is just with even the 2 committees broken up that are issue-based, those issues, especially in the second committee, are very, very, very heavy. So the mass incarceration, health harms, and education are very, very heavy to put in one advisory committee. Also, we know this, it's much easier to schedule advisory committee meetings without all of the, notice and I won't say pomp and circumstance of all of that, but, we know it's a logistical, basically nightmare for the DOJ. I also know that going into this phase where we are essentially trying to answer these questions and present possible proposals based on what I'm thinking is, in addition to direct cash compensation, which you kind of talked about through with the economists, the monetary, non-cash, and the non-monetary. That is just really hard to have an advisory committee with 2 people and then come back to a body of 9. Just with the amount of substance that I think will take place and what will be required from members. So I just want to to put that out there. And then the third thing I'll just say is just based on the 5 questions. One is I want to get clarity of what the direction the task force gave yesterday with regard to the economic, let me say it right, economic expert committee, and exploring some of the questions, but in particular the California residency question, which I think will be a global, it may be a global answer that we come up with as an umbrella for all of the issues. So just, I wanted to throw those things out there. Thank you.
Thank you. Any other comments or questions from the task force members? Preliminary thoughts about what we talked about and what was presented before our break?
So this is just in the nature of thinking out loud. Various members of the task force have subject matter expertise on a number of their areas. They have staffing. Also for the legislators, there may be particular interests in different subject matters, and depending upon what Member Lewis and the chair proposes, maybe we could work within that framework to kind of self-select. I mean, if there are task force members that are interested in any particular area and really want to pursue that, with great gusto, enthusiasm, maybe that would be a natural way to proceed. Just find out what people's interests are.
So I think that Member Montgomery Stepp and Member Tamaki's comments are in perfect alignment with, I think, what we discussed. So, Member Lewis, yeah.
Okay. Thank you both for those comments. And Chair Moore is right. They are rather in line with what we're trying to propose. So there are a couple of issues that we have to address. One is the timing of the work going forward, the limitations that we have in terms of our ability to meet, our availability to meet, and of course, Bagley-Keene and the immense work that is ahead. And so we are trying to basically find a way to accommodate all of those constraints while still, I think really trying to do this thing right. So if you can go to the first page, which is staff recommendation regarding advisory committees in your handouts. As Member Montgomery Stepp mentioned, right, the 5 questions really are a kind of universal concern. And there's an issue, given Bagley-Keene, where I think there's going to be a challenge in trying to
Sorry, Member Devanka Lewis, we just want to make sure everyone's on the same page. We're looking at staff recommendation, so that's page 3.
Yeah.
Okay. All right, we're all on. Just scroll down.
Is that it?
Yeah,
that's it.
All right, yeah, that's it.
Okay, so again, as Member Montgomery Stepp mentioned, the 5 questions really are universal ones, or global ones, is how I think you put it. And so the recommendation is that Chair Moore and I would continue in our capacity as now one of the advisory committees and work on those 5 questions and how they apply to the 6 areas that come up in bullets 1 and 2, starting with unjust property takings and ending with education. Beyond that, and I should add that we're talking about these areas being areas of concern around coming up with recommendations for compensation. And so beyond that, what we would like is to propose that in clusters of 2 topics, we invite task force members to volunteer to join in an advisory committee of 2 members to tackle 2 topics each. So for example, there would be a pair of task force members who would work on unjust property takings and the devaluation of Black businesses. There would then be a second advisory committee of 2 task force members that would tackle housing discrimination and mass incarceration. There would be a third advisory committee of 2 task force members that would work on health harms and education. And so these are all very weighty. And the idea of 2 people, working on these, is daunting. But the purpose is to bring back recommendations to the task force. So the responsibility is not to, make final recommendations, but to, work with the DOJ and with the economic experts team to, kind of do a deeper analysis and to bring back to the task force some preliminary recommendations for us to all to vote on and to move ahead with. And so, as I mentioned earlier, Chair Moore and I would then work on what could be considered the kind of 4th advisory committee, which would be tackling the 5 questions and thinking about them, in that global manner, as Member Montgomery Stepp mentioned earlier. Okay, so there's more work to be done. And so if you go to the following page, which is page 4, there's a section working with DOJ staff on areas not addressed in experts' list of atrocities. So as mentioned by the experts team yesterday, these are the areas that came up in our preliminary report, in which we've heard testimony on over the past year, that they said that they are unable to quantify as far as finding a compensatory model to advance as a form of redress. And along with the section below, remaining issues, these 2 sections actually represent areas of our scope of work that fall outside of a compensatory framework. And so what we would ask task force members to do is to work with the DOJ, but not with the economic experts team, on coming up with what we might think of as non-compensatory, non-compensatory, yeah? I don't want to drop the O's too many times. Recommendations to bring back to the task force. And so again, that would be on issues of enslavement, racial terror, political disenfranchisement, the pathologization of the Black family, control over creative, cultural, and intellectual life, the racial wealth gap, in addition to, under the remaining issues, elimination of racist laws and policies, appropriate ways to educate the California public on our findings, as well as how and what form a formal apology should take. And so in total, in those 2 areas, there are 9 topics. And so what we will be asking is for each of us to take on one of those 9 topics. And so in that regard, it would be an advisory, committee of 1, so to speak. But again, the role of us in that capacity would be just to work with DOJ and try to find some form of recommendations to bring back to the task force that we can then work with to provide our actual formal recommendations. So the hope is that if we can do this, then we might actually be able to, have something significant to report on in our December meeting, which, unfortunately will likely be our next meeting because, as noted, we were unable to find a quorum to meet before then. So that's the proposal from Chair Moore and myself.
Thank you, Member Javon Scott Lewis. Vice Chair Brown, did you have a comment?
Madam Chair, members of the task force to get us moving. I volunteer for harms and health and education.
Yeah, so let me just first summarize and make sure we're all on the same page. Thank you so much that was very clear, Member Devon Scott Lewis. So I think the proposal that we're coming up with is that we would have one advisory committee that comprises of myself and Member Devon Scott Lewis to address those 5 questions that seem to be more global in nature around damage timeframes, residency requirements, and all of that, right? So there's one advisory committee, again, that comprises of me and myself and Jovan Scott Lewis, who would deal with those 5 questions. Then there will be 3 additional advisory committees that would take or volunteer to take 2 topics each, and that's on page 3. And then we go to the second page, we would, as a task force, each of the 9 members would volunteer to take 1 of the 9 topics on that second page, right?
That's right. And I think, in listing the groupings for the compensation advisory committees, I just listed them in order that they're listed. So, I mean, if you want to discuss what, better pairings there might be, if you want to, go back to Member Tamaki's, suggestion earlier about finding, areas that members are interested in, we can do that. But I made those pairings for convenience and just for clarity, so you could follow them on the sheet.
Okay, and Vice Chair Brown, going back to us coming up with better pairings, I think he already volunteered to do health harms and education, so that could be a pairing. So that would mean we would need another person to volunteer with Vice Chair Brown to serve on that committee, correct?
Yeah, I mean, what I'm saying is that I'm not necessarily recommending that these are the pairings. If everybody's fine with those pairings, then we can move ahead with them. I'm just clarifying that I listed them because that's the order in which they were listed in the actual sheet we were provided by the DOJ.
Yes. I'm just saying, since Vice Chair Brown already took the initiative, I think we should go for it.
All right.
And what do you all think about that? Member Montgomery Step?
I just have a clarifying question just about the second page, the areas that are not addressed in the experts list of atrocities. It says 9, but I'm counting 7. I think plus the remaining issues. Okay.
Plus remaining issues.
So it wouldn't be, okay, all right, got it. Thanks for clarification.
Yeah, so there's 6 under the table of working with DOJ staff on areas not addressed in experts list of atrocities, and then 3 remaining issues for a total of 9. Yes, Member Tamaki, you recognize.
This is in the nature of thinking out loud. It's not a proposal, but for instance, eminent domain and housing is subject matter related. So that might make it easier for pairing. Mass incarceration over policing, and some of the things about education, especially school to prison pipeline and discipline, is related to each other. I don't want to break up things that have already been suggested, but that might be another related pairing. I'm just trying to figure out ways to create commonality and synergy.
Yeah.
So
streamline the work.
Yeah. Black business, maybe as a standalone, I'm not quite sure, but at least I see 2 categories where there's some overlap.
Okay, so going back to, go ahead. Yeah, sorry, Member Holder, you're recognized.
Just another idea to throw into the pot. The remaining issues also seem kind of global and thematic to me. So I am wondering whether for each of the harms, however we separate them, whatever advisory committee is doing a harm, might want to do those 3 remaining issues as related to the harm that they're covering.
Sure.
That's just one other way to conceive of this, to formulate it.
Yeah, I mean, I think we could, and so that's why I was recommending we do the stuff on page 3, and then we can just say, well, because individuals would have to take on what's happening on page 4. And so I think you could absolutely accommodate that.
Yeah.
For sure.
So I guess the first step is to really hone in on what the committees are gonna be. And then assign the individual, if we agree to that, the individual. And I do, just as far as the 3 committees with the 6 issues, they're all interconnected. Housing and houselessness is also connected with the criminal legal system quite a bit. And then eminent domain, there are quite a few Black businesses that were lost based on that too. So it's kind of tough. So I can, I'll go with the task force. I am interested in Black business devaluation.
To Karen.
I would take either one, what you proposed or what.
So maybe that's a logical connection, and houselessness would go with another category.
There's an intersection between houselessness and criminalization. Yes.
We did mention there how watering holes have been destroyed. So the houselessness, eminent domain, and our basic communities have been destroyed through eminent domain. They're all related, those 3.
Mm-hmm.
Can you repeat the ones you said?
The destruction of our watering holes, our cultural enclaves, vis-a-vis Ellsworth, South Central Los Angeles, the Fillmore. Where? Beverly, yes. Along with them, that's land.
The restoration of the Black watering holes?
Yeah, I was just saying that the restoration of the Black watering holes seems like it would fit under the rubric of unjust property takings by eminent domain and devaluation of Black businesses.
And we should remember that these areas are what, the atrocity areas that the economic experts team, with guidance from the task force and the advisory committee have come up with. Is what they presented on yesterday. And these are the areas that they have identified that they have data for and around which they can quantify economic redress.
So I think, I think we reworked the pairings. So would it be the evaluation of Black businesses and unjust property takings as one pairing, mass incarceration, over policing, and housing discrimination and houselessness as another, and then health, farms, and education?
Yeah, that's the original That's
the original?
Yeah, that's the
Yeah.
You're a genius.
So great, it works out. All right.
Yeah, I'm happy to work on the second one in that pairing, the housing discrimination and disproportionate Black mass incarceration.
Okay. Okay.
Unjust property taking.
Okay.
Eminent domain.
So that comes with the valuation of Black business.
Yeah, I'll
Yeah.
do that. as well. I mean, I think it's a nexus there for sure.
Yeah.
All right.
Monica, did you?
I'm done.
So who's
So,
Senator Bradford and who's?
yeah, I got Senator Bradford.
And,
But you, done.
oh, okay. Yeah, I'd be happy to do that with Senator.
You want to do that one as well?
Unless, did you want to do that?
No, Camila and I are doing the 5 questions. So Camila and I aren't.
Monica, did you?
I did want to do the valuation of Black businesses.
So maybe
Unjust.
you and Senator Bradford
Okay.
on unjust. Yeah. Okay.
So then what would remain is health, harms, and education, which Brown already volunteered for.
And then, so that would leave you done,
Yeah.
because you haven't signed up for one.
And Pastor Brett.
Okay. All right.
So to recap.
Yeah, so, Reggie,
Oh, Reggie.
so happen, skip class and you actually benefit sometimes.
What expressed interest in what did they say?
No, because Reggie's not here. Sorry.
He gets mass incarceration.
Yeah.
I mean, really, as public safety chair, he expressed interest in that.
So we have, so the thing is that there was always going to be one task force member kind of left out of these pairings.
But then he'll have an opportunity for
Yeah.
the remaining issues.
Yeah. So what we can do is we can give him, we can assign him something in the next section that might be befitting his stature and status. Yeah.
Okay, so to recap or summarize, there's going to be on this first page 4 different advisory committees. The first committee would comprise of myself and member Jovan Scott Lewis, and we would handle those 5 questions. The other advisory committee would be on health, harms, and education, and it would comprise with Vice Chair Brown and member Tamaki. The other advisory committee would be on the evaluation of Black businesses and unjust property takings, and it would comprise of Senator Bradford and member Montgomery Stepp. And the other advisory committee would be on mass incarceration over policing, as well as housing discrimination and houselessness, and it would comprise of member Grills and member Holder. Yes.
The point is well taken that member John Sawyer is on the Public Safety Committee, chairs it. So if, as I'm thinking out loud, I could be replaced on the housing discrimination and mass incarceration by member Joan Sawyer. And then instead of being on any of the 2-person committees, I could simply take a handful of those individual ones. So I could take the racial terror and the pathologizing of the Black family. And if necessary, enslavement.
You don't have to volunteer for more work, member Grills. You don't have to do that. But I do like the move. Yes, so now member John Sawyer replaces member Grills. I like it. Yeah. I think the point.
Your subject matter expertise is in mental health. And did you want to do the healthcare instead, or? Okay. Well, I think the other stuff is equally important.
Oh, wow. Okay. Ladies and gentlemen. So that's a really good argument, right?
I'm calling you.
But you're okay?
Expert.
Okay. So I'm member Tamaki. Member Grills says not today. Okay.
So member Grills, did you want to stay on that committee or swap out and?
I can swap out and take on a
few of those individual topics.
And just to clarify, all the members, every one of these issues is going to come back to the full task force, and every member is going to have the opportunity to weigh in on every component of the report with suggestions and edits and things like that. So everyone will be involved in every part.
Yeah, I don't think you need to take on the extra thing. Yeah. No. Yeah, you can. Yeah. Okay.
So, okay, we can move on to the remaining 9 issues, but I just wanted to clarify about that last committee. I also don't want to volunteer John Sawyer for something.
Well, he just, the member girls did volunteering.
And Joan Sawyer, just so you, Joan Sawyer yesterday did say he expressed interest
And volunteered me.
and volunteered you. So now in turn, you're volunteering him back when we're actually doing the.
Okay, so maybe, do we need to, maybe just so we can just, maybe codify this via motion so we can just move on to the next 9 items?
Can we do the other section first?
Okay, yes, we can do that.
But you want to confirm who's doing
So
what?
to confirm, there will be 4 advisory committees. One will comprise of myself, member Devon Scott Lewis, who will handle those 5 questions. The other will be on health harms and education, which will include Vice Chair Brown and member Tamaki. The other advisory committee would be on evaluation of Black businesses and unjust property takings, which will comprise of Senator Bradford and member Montgomery Stepp. And the other advisory committee would be on mass incarceration and over policing and housing discrimination and houselessness, which will comprise of member Holder and member Jones Sawyer. So we'll go to the remaining 9 issues. And the original plan was for each of us to pick one, but we can talk through whether that's still the plan or if we want to do something different.
Well, I'm particularly interested in appropriate ways to educate the California public of the task force findings. And unless somebody has a burning interest, that I certainly would defer to. That's one I have a high interest in.
Great.
And, with that one taken out of the remaining issues, it seems to me that there's a nice synergy here. So if you have elimination of racist laws and policies, how and what form of apology, I think that those are thematic and those can go with each of the 3 harms. Do you know what I mean? So I think I think each of our groups should
Right.
actually be looking at
Right.
what should a formal apology on that issue look like, and what are the racist laws underneath that rubric,
Right.
and how to get rid of it.
So would that be like an advisory committee, those 2? I mean.
Yeah, so we divide those up as well, basically. That should be fine with, there's no
Okay.
baby key.
Okay, like something to keep in mind.
Mm-hmm.
So you're saying instead of having an advisory committee or a designee on appropriate ways to educate on formal apology and elimination of racist laws, each advisory committee or designee is going to do those 2 for their subject.
That's right.
Correct.
Okay, there you go. Thank you. Since there is an expert, I think, coming in on the elimination of racist laws and policies, so logistically, how would that work?
So we have a team of attorneys at Loyola Law School who are working through putting together a sort of a list of all of them, but whatever we can find in terms of racist laws in California. I'm trying to think, it also includes case law and things like that are still on the book. So what we could do is we could facilitate from that compendium, which they're going to produce, and the idea was for it to be sort of added on to the report. We could work off of that compendium with each group to identify the ones that are key to the different subject matters. And then each group, individual or advisory committee could figure out what they want to do in terms of the elimination of the ones that are applicable to their group. Some of them are going to be overlapping. Some of them may not fall into these categories, but we can figure that out.
Okay, thank you.
So if each of the advisory groups have to consider those two topics, and that would just mean it would just be 7 advisory committees, right? Instead of 9? Yeah, 7 individual topics instead of 9. I can do the racial terror. Okay. Racial terror. I would like to volunteer for control over creative, cultural, and intellectual life.
Can I just clarify for my notes, because I'm keeping notes on who's going to be responsible. I have Member Grills on racial terror, pathologizing Black families, and enslavement. Member Tamaki on educating the public, and Member Moore, Chair Moore on creative, cultural, intellectual life. Oh. So you're just doing racial terror?
Yeah.
Okay. So I'm gonna figure out. The remaining issues are enslavement, political disenfranchisement, and the wealth gap.
Family.
Oh, and pathologizing the Black family, sorry.
I'll work on the wealth gap.
So the remaining,
I'll do the pathologizing the Black family.
And I think just to kind of contextualize what enslavement means, you know, in this context, we are talking about, you know, the effective indentureship of incarcerated, you know, Black Americans. You know, we're thinking about those social forms of control and servitude that continue to take place.
I'll take enslavement too.
You want to take 2? Okay.
So as I have down, the remaining 2 are political disenfranchisement and pathologizing the Black family.
Remember Montgomery step will take the pathologizing the Black family, right?
You know, I forgot about the political disenfranchisement. I should probably take that one.
Okay.
That's more.
Okay.
Okay, I mean, we were doing individual, we can set up an advisory committee though. That'll be fine.
You can do that.
You just need it covered, to be honest.
Yeah, we're doing, we get 2 for 2, okay.
So you want to, yeah?
So you would do both, pathologizing the Black family and political disenfranchisement. So that leaves pathologizing the Black family.
What happened?
So there's one remaining issue, which would be pathologizing of the Black family.
So you put 2, you put doing 2 out into the universe and it's come back to, yeah. It's,
Give that to Reggie.
It's,
Give that to
it's,
Reggie?
Give that to Reggie.
Will you give it to Reggie? All right, I'll give pathologizing.
So wealth gap is gone.
Camila, I mean, Chairman.
Did there any items?
Okay.
Okay.
So in terms of the remaining issues and the areas not addressed in the expert list of atrocities, there would be advisory committee of 1 that would comprise of Member Tamaki around educating California's public on our findings. The other committee would be comprising of member Grills that would cover racial terror and pathologizing of the Black family. I would cover control over creative, cultural, and intellectual life, as well as enslavement. Jovan will cover the wealth gap, and Monica and Bradford will cover political disenfranchisement. Right. No, we're all. So the only two that are technically remaining are the elimination of racist laws and policies and what form a formal apology should take. And we just all agreed that each of those committees that we came up with will incorporate that into our work.
Right.
But I do have a question, because do you all envision that there's going to be one major apology or apology for each? Like,
maybe it makes sense, of course, to have one global apology, and maybe that goes under how to educate the public, because it has to do with memorializing, the wrong and the need of acknowledgement and reconciliation and reckoning. So maybe if you can combine two, then I do those two.
okay.
So I mean, it's just that, with the issue of apology and the elimination of racist laws, these committees will go away and, figure some stuff out and then come back, and then we can decide if we want to. Yeah.
I would think maybe Michael, you can weigh in on this, but I would think the compendium of racist laws are pretty concentrated in specific areas, like housing, for instance, racial covenants, some portion of the Constitution having to do with that. So maybe that's not such a big lift, because it will already be focused and it'll be concentrated in specific areas. So maybe it's not something we need to have a separate subcommittee or advisory committee on. What is your sense of that?
That's my sense. I mean, I think it'll work either way. We can either do it where we do have just the compendium and it exists and it's factual. And so it can be allocated to each of the different subcommittees, or one subcommittee can handle it either way. Or it's also something that can wait until after everyone's done with everything else and then comes in and gets added to that at the end. So however you'd want to do it. And I think same thing for apology. If you want to have apology components that arise in each of the various different contexts and then one global apology, either way you want to do it, we can make it work. And again, I just reiterate, it's all going to come back to the entire task force anyway. So whatever these various advisory committees or individuals who are working with the DOJ, everyone will still have an opportunity to weigh in on the nature of the apology, how it should be made, et cetera, however it's done.
Okay. I want to reiterate that I do think each group should look at an apology that's specific to the harm.
I think that's what we're proposing, right?
Yeah, I think the
And that's so that we don't just siphon that off. Yeah.
Right.
Okay.
That sounds fine.
So each of the advisory groups will come up with what an apology might look like for that particular harm, come back to the task force, and is the plan still for member Tamaki to kind of take all those thoughts about what a formal apology might look like for each of those discrete areas, and then you would help to come formulate a global apology?
Yeah, I'd be happy to do that. It's just a suggestion. Yeah, sure.
Is that what we said, or?
Yeah, that's okay.
Okay. Okay, so I think now we are at a point where we can take potential action on what we've discussed. So I'll just summarize, and then maybe we can entertain a motion to just codify what I summarized, unless someone wants to come up with the motion right now. Okay. So in summary, I entertain a motion to codify the following. that there will be first, an advisory committee that comprises of myself and member Jovan Scott Lewis, who will answer those 5 questions on page 3 of the handout. The other committee would comprise of Vice Chair Brown and member Tamaki, who will cover what policy and compensation recommendations might look like for health harms and education. The other advisory committee will be on the evaluation of Black businesses and unjust property takings, which will comprise of Senator Bradford and member Monica Montgomery Stepp. The other advisory committee will be on mass incarceration, over policing, housing discrimination, and houselessness, which will comprise of member Jones Sawyer and member Holder. Then we'll have other advisory committees to cover remaining issues and areas not addressed in the experts list of atrocities. One of these committees will comprise of Tamaki, who will cover educating California public on our findings, as well as what a global formal apology might look like. Member Grills will be on a committee on racial terror and pathologizing of the Black family. I will cover control over creative, cultural, and intellectual life, as well as enslavement. Jovan will cover the wealth gap, and Senator Bradford and member Monica Montgomery Stepp will be on the committee covering political disenfranchisement. With the caveat that each of these committees will have to consider racist laws and what an apology might look like for each of the discrete areas that we've been assigned.
I'll restate the motion for the record. Just,
Well,
For
someone
each
has
motion. Each of the advisory committees is set by motion, right? So that motion is going to be made, and at the time that motion is made, whoever is going to be the maker of the motion will yield to the staff person to state that motion on the record, unless you have it written down specifically as stated. If not, then it would be better for the attorney here to make that motion so that it's straight on the record. Because sometimes it's difficult to hear. Does that make sense to do it that way? So whoever is going to be the maker of the motion, the chair is going to ask, she is prepared now to ask for a motion. And you'll go all the way through. I think there are 9.
Yeah, there's 9.
Okay, so that's why we need to do it one at a time so that it's clear on the record. Okay, so Madam Chair, if you would say you're ready to entertain a motion.
Okay, yes, that's great. So I'm ready to entertain a motion on the advisory committee around those 5 global questions. Yeah, so maybe the person who's on the committee can. Okay.
okay.
Well, it would make more sense if, like, for instance, I'm saying I'm ready to entertain a motion on the advisory committee around those 5 questions. We know who's going to be on that committee. Jovan can just make the motion, and then for health harms and education, Brown or Tamaki. You can make a motion.
As long as somebody states the motion with the subparts. Someone has to state the motion. I can do that for you if you'd like.
Yeah.
Please. Okay. So somebody yielded to me already. Dr. Grill.
Yeah.
Okay.
So, Madam Chair, are you expecting a vote on each motion, or did you? Huh? You want to do a cumulative motion, so she's going to do the subpart, and then we'll do one vote, is what I'm saying, as opposed to 10 votes.
Right.
And
Okay.
if anyone has an objection to any aspect of it, then you pull that out. Otherwise, we'll do it all together.
Yes.
Okay? So if you disagree with any part and you want to do that separately, then that's what you can do. You can pull that component out. Otherwise, it will be one motion, one vote.
One motion, one vote. That's right.
Okay?
Uh-huh.
If, yeah, sir.
We've all been listening. Let's go ahead and vote.
Member Grills has already yielded to the staff.
Okay, so on Member Grill's delegation to me, I will restate the motion as I have it down. It is a motion with 10 subparts. Subpart 1, that Chair Moore and Member Lewis, as an advisory committee, will address the 5 questions laid out by the experts. Part 2 is that an advisory committee of members Bradford and Montgomery Steppe will address eminent domain and black business, devaluation of black businesses. Part 3 is that members Jones Sawyer and Holder address the components regarding incarceration and housing. Number 4 is that members Brown and Tamaki, Vice Chair Brown and Member Tamaki, address health and education. Number 5 is that Member Grills will handle racial terror and pathologizing the black family. Subpart 6 is that Member Tamaki will handle educating the public in conceptual global apology. Subpart 7 is that Chair Moore will handle enslavement and interference in creative, cultural, and intellectual life. Subpart 8 is that Member Lewis will handle the wealth gap. Subpart 9 is that Member Montgomery Steppe and Bradford will handle political disenfranchisement. And subpart 10 is that each of these groups will address the elimination of racist laws and policies, as well as specific apology components for each subpart.
Second.
Excellent.
Okay, so it has been properly moved and seconded by Vice Chair Brown that we will adopt the restated motion with 10 subparts. Is there any discussion of the matter? Okay. Hearing no further discussion, I'll turn to Parliamentarian Johnson for a roll call vote.
Thank you, Madam Chair. Chair Brown?
Chair Moore? Aye.
Oh, my goodness. Chair Moore?
Aye.
Vice Chair Brown?
Aye.
Member Bradford?
Aye.
Member Grills? Aye. Member Holder?
Aye.
Member Jones Sawyer? Member Lewis?
Aye.
Member Montgomery Steppe?
Aye.
And Member Tamaki?
Aye.
Madam Chair, there were 8 members present and voting. There were 8 ayes and 0 nays.
Thank you, Parliamentarian Johnson. There are 8 ayes, 0 nays, and so the ayes have it and the motion carries. So the next item on our agenda is item number 21, which is discussion and action item agenda for the next meeting. And that will be?
No, it's 20.
We're still on 20, which is the future hearing schedule, I believe, yes?
Oh, yes, excuse me. We're still on 20. So now we'll go to the last.
Page 5. Yeah. First, as I mentioned, the only quorum that we have would be on the days of December 14, 15, and 16. So the first matter of business, I think, either in this agenda item or in agenda item 21, if you want to defer to the next agenda item, is to set that date. But starting from that date, we then have a dash to the finish. You can see that this proposed hearing schedule, actually, which I'll turn over to Member Lewis and Chair Moore to talk through, has a meeting scheduled every month. That presupposes we will have a quorum every month. So we will need to get a doodle going for the rest of the fiscal year, essentially. But with that, I'll turn it over to Chair Moore and Member Lewis if you want to discuss this, or I can also put up the other hearing schedule, which was the one circulated if you prefer, with the meeting materials.
So we're just covering what's on the page?
Well, it's up to you if you want to cover what's on the page and showing right now, or if you want to revert back to what was included in the meeting materials. This is incorporating some of the changes and the reporting back that we've just gone over with the advisory committees, which had not been in place when the original future meeting schedule was circulated. So this is essentially up to the minute following the vote you just took.
I think the other hearing proposal that we came up with was primarily based on the 5 forms of reparations under international law, but I don't think we're organizing. I think based on our conversations, we're not doing that anymore. So
I can discuss the thinking behind this if you want, unless you want to, like I said, all we're figuring out right now is, do you want to talk through this proposal or do you want to go back to the
might as
proposal?
well, yeah, I don't think we're going back to the original one, so you can proceed.
Okay, so this proposal is built around having a final report that incorporates essentially what we've just been talking about, all the different issues written up, with input from the experts, et cetera, that builds on the interim report, sort of builds out that interim report to include all of these issues that you're discussing. So it is, this schedule, as we propose, is built around a series of returns from the advisory committees to report back on their work, get the input of the entire task force, give input to Department of Justice so we can, and the experts, so we can continue to work up issues as we move forward, and then incorporating some amount of public testimony on, as we've delineated, potential remedies and remedial programs that are occurring out currently, experts for how to address the harms that are delineated in the report, in the interim report, testimonials on how racist laws have affected people, and legislative experts and legal experts recommendations on what recommendations from this task force should look like once we get into the part of the task force's work that discusses recommendations for the legislature's implementation of the recommendations in the report. It's a lot of recommendations. So we've also planned to follow similar to how we handled the first report, which is to come to the task force with outlines for what we're calling the second report. It's really part 2 of the final report. We are planning to come back February of 2023 on the schedule. That presupposes that we're going to all be working with the experts, task force members and the experts working together and coming back and reporting back and having outlines of essentially very high level conclusions and what people can expect to be in the final report for the task force to discuss and give some direction to both the advisory committees, the DOJ, and the experts. Then, like last time, we will take those outlines, convert them into a draft, which will come back to the task force for awareness, but not necessarily a vote. We'll have the same discussion that we had the last time, where all of you will have an opportunity to provide edits, suggestions, comments for us to incorporate. And then finally, we'll come back. We scheduled here for May of 2023 to come back with a final report to present for your approval, at which point we will then finalize and prepare for publication. Any questions? The one thing I will add is that as we go through this process, you'll have an opportunity to set for each meeting what witnesses you want, how you want to have public information come in, if you want that. But a lot of this is going to be work of the task force members with the task force members. So we'll want to keep a lot of time for there to be that work and discussion. Right.
It's pretty straightforward. Any other comments?
So could you just state clearly, what you said was very clear. I just want to say definitively, not clearly, at what point basically would you be looking for us to be prepared to kind of move towards the drafting of the final report? I'm trying to get a sense as to how many meetings do we have between now and that point, before, DOJ is like, okay, we need to start translating, what you all are doing into written form.
Well, it's a great question. And you're right, the meetings don't necessarily match up with that. So I can report that we already have deputies that are starting to work through, based on the recommendations you all already concluded in the interim report. We're already at work on the second report. So that work is starting. It's going to continue. What we're hoping is, now that we've voted on the advisory committees and the individuals, we're going to start working with you. We're going to connect you with deputies who are working on these subject matter areas. We're going to connect you with the experts. And so the work essentially starts now. Essentially, we would like to have probably those outlines that we'll be presenting in February done on our end, maybe even by early January, mid-January, collectively with your input, so that we can then get going with drafting. The drafting, in order to meet this deadline, the drafting is going to happen at a very early stage.
Right. I'm just trying to figure out how much time we have for deliberation, to actually talk about reparations, before we have to somehow accommodate the timeline of the production of the second report or final report.
Sorry, was that a question from me?
So in the timeline, for March, you have presentation of initial draft of report 2 by advisory committees, experts, and DOJ staff, the task force discussion. So what does that actually mean in practical terms? What does that actually look like? What is that?
So if you remember from report 1, when we presented the draft, that was a fairly complete draft. That would be our expectation. So I think that's where we need to be. And it's down for March. So if we get a quorum, and the only quorum we have is in early March, that's putting a lot of pressure for us to get it done by late February, so it could be included in meeting materials. An alternative could be, if we can't get a quorum in March, we have a meeting in early April, and then the outline comes out later. We'll have the ability to move that around on a meeting by meeting basis. So this is you're voting on this right now. Essentially, there's two or three things that are really being locked in right now in terms of this vote. Are the meetings going to be in person or virtual? Are these the locations that you want the meetings to be in? Because then from there, we're going to do the doodle poll.
Right.
We're going to set the locations. Beyond that, if you want to change something about a particular agenda for an individual meeting, if we get to the meeting in December, and there's still a lot of lack of clarity as to how things are going in terms of the developments of each of the advisory committees' workload. We can maybe push things back a little bit. So you have that flexibility, and that can be a meeting by meeting thing. But it'll be a matter of, this is sort of everybody's expectations.
Okay, no, thank you. So I asked for that definitive follow-up, just so that everybody on the task force realizes that we're basically, I think, expected to have the thing worked out by that time. So in other words, this is not us going into March, April, still trying to figure out what reparations are. And so that increases the burden on our advisory committees to take that element very seriously. Because when we meet, we will be actually bringing to the table, the majority of the work that can be done. And so that work won't actually be done in these meetings. And so I just want to make sure that everybody, fully appreciates the consequence of the timeline on what we are going to be able to do in the remaining time of the task force. And I say that because, so Chair Moore and I came up with the schedule that really, tried to accommodate, prolonged discussions on compensation, right? Because we are cognizant of the fact that we actually haven't talked about reparations directly, as it were. Despite, some in the press saying that we had done so, we haven't. And so, yeah, and so I just want to make sure that we're fully aware, of what's at stake here.
So between now and March of next year, the initial draft of report 2 is going to be presented.
So this feels like an even shorter timeline than we had to work with for the interim report, listing out the harms. Not that this second part of the report or this final report needs to be anywhere near as long, but it does require a considerable amount of crossing T's and dotting I's in terms of any recommendations need to be cross-referenced with a bunch of other things to make sure that it makes sense and it's something that legislators can work with. That being said, for the interim report, there were certain members of DOJ that worked specifically on certain chapters. Will there be something equivalent to that so that those in the various committees have a point person that will essentially be immersed in the same area or body of work as the advisory committee members?
We are still working out staffing. Obviously, you know how much staff we used. We had working on the first report. That report was very much focused on legal and historical research, putting together the compendium of documents and the bibliography and everything else that we did in that report. I think with this report, you all have point people to talk with. I have to think about exactly how we'll be able to staff, whether it'll be, I don't know that it'll necessarily be one person with the subject matter or teams of deputies, but we'll have the staff that we need to be able to support you. And we will have, probably even next week, because I'm sure they're watching this right now, and they know what's coming. So we will endeavor, now that we have a vote on who's going to be handling what subjects. I'm going to meet with a team next week. We're also going to meet with the experts next week and start working out similarly who on the expert team, if the expert team is going to be handling different specific issues among them, or if they're going to be processing things collectively. So hopefully we'll have that all worked out, and we will be in communication with each of the advisory committees or designees on their subject, because we do intend to be moving forward with all of it all together. There's nothing that's going to be sort of, we're going to do these topics now and then come back to these topics. We've got to, because of the time frame, we got to do everything together. So you'll all have new friends in the DOJ.
New BFS. And so, I'm sorry, a related question is, do you know when we will be able to get a copy of the racist laws and policies that may, have bearing? So I'm thinking, for example, in pathologizing the Black family, there are laws on the books related to relative caregivers, and that really decrease the ability of Black families to take in children who are being removed from their homes.
That's a good question. I believe we're hoping that's going to be, well, we have a draft, and we'll work with the experts to try to get an answer to you this week. I think we should have that by January. But we'll work on it. We can also, one of the things we can do is, now that we have you all engaged on the various subject matter areas, if we have a draft that we can provide, maybe you all can have stuff that you add into it as well, or suggestions.
You're recognized.
Thank you. I just want to, since Chair Moore, Member Lewis did prepare a draft, and I'm feeling, I guess, like there's a little bit of not conflict, but based on our decision that we just made about the split up of the committees and kind of what the vision was based off of what you all prepared, I just want to make sure that we're being as inclusive as possible as to what you all thought was important for the task force to discuss, because I'm not making the connection. So if you could just take a couple of minutes to kind of walk through your process, so I can make sure that what we're doing and deciding this is going to take us through to the end.
Does staff have our proposal on hand?
Being the meeting materials, agenda item 20.
So what I can say is that, part of our thinking was wanting to make sure that we provided enough time for the task force to deliberate over the issues of compensation and to deliberate over guarantees of non-repetition, and to think very clearly about what kinds of policies would then complement the kind of compensation that we might be recommending. And so, just to answer your question, if there's a conflict, I don't think there necessarily has to be a conflict, as long as in the meetings that we have between now and when we're expected to really meaningfully contribute to this draft, that we have enough time in each meeting, to spend on those issues. And so that could be structured as simply as, those advisory committees continuously reporting back each meeting, and us deliberating and incorporating that feedback, as opposed to, filling the time with too many witness panels and testimonies, which at this point, Dr. Brown, I know you have, a phrase to help us understand, I'm drawing a blank, but I'm just looking to you, but I know, the patting the head and rubbing the belly and the other one. But I really do think that, we can do it in the time frame, as long as we're not, we're not taking up too much time passively over those meetings. So I mean, that's my personal view.
Okay, yep, I would definitely agree with that. And if, if we could be as focused as possible, if we have additional panels specifically to, to potential remedies and just very clear examples. I think we have enough in the record. And I would agree that it really needs to, as Mr. Newman said, it's coming from us, and it needs to be very substantive at this point, whatever we do from here on out.
So entertain a motion at this time around our future hearings.
And I think, Mike, you needed us to actually also talk about the locations and so forth.
I will note a
And
couple
there's
things.
another issue as well, right?
Right, so I'll note a couple of things. Obviously, there's, number one question is virtual or in person. As you all know, the legislature enacted a Bagley-Keene Act holiday for this fiscal year. So until the end of the task forces, or the sunset of AB 3121, this Bagley-Keene Act holiday would allow the task force to go back to being virtual meetings. So that's number one, and that would be totally up to your collective vote. The other thing I'll note is that the locations in the proposal that I've now circulated, included in your materials, did change slightly from the original one in the materials. That was because of consolidation of meetings. The meeting schedules changed a little bit and were consolidated. And so there are questions the task force should address in terms of where you want meetings to occur. I remember there was a significant desire to do something in Allensworth, and also the locations that are delineated cover, I believe, all of the locations that came up when we first talked about where do we want to have all the meetings if we do them publicly. So anything you want to change in terms of location, obviously.
Yeah.
Yeah.
Okay, now I'm back. So actually, that was probably a good ending time anyway. You all get to decide where you want these to be generally, and then we'll try to work backwards once we get your availability in the doodle poll.
So can you give us a little bit of background on how difficult it is for the DOJ to set up meetings, how labor intensive it is? And the reason I ask is that this agenda and what has to be done is pretty breathtaking to me in terms of the amount of work, both on the task force side, the advisory committee meetings, the meetings with the Department of Justice folks and the experts, to then basically start working up the drafts by like March. Is that right? Something like that. So is it all the same? In other words, even though we have, and there's strong reasons to meet in Bakersfield or some of the other locations, some are more remote, obviously, less accessible, more accessible. Some of the facilities that need to be set up, we're having trouble just getting, our Wi-Fi connected here in the, California Science Center. And so, these hours begin to matter, right? If it's another day of just travel, there's no easy way to get to the Central Valley, unfortunately. And so can you give us a little insight about whether that's a concern on the schedule or not?
Sure. So thank you very much for mentioning that. I will say we have a huge staff here that are putting this on. Obviously, it's also a Saturday. And it does require staff to drive down from Sacramento with all this technology. It's all based out of the Sacramento office. So wherever we're having the meeting, Trini and her team are going to be driving down with all this equipment from Sacramento. I will say in this location, we had a huge amount of support from member Joan Sawyer and member Bradford staffs. So that was certainly helpful. But even with that, obviously, you've seen the technological issues moving from room to room. So there are issues that come up with having meetings in person. And I think it's just everybody's basically patience with those issues as they come up. But it is significant resources in terms of staff that are here from the Department of Justice, as well as sometimes if we would ever have to get paid for a room, pay for a location at a hotel, that would be a burden. And then the amount of time it takes just to set up. I think Trini and her team were here last night until very late, and then back here this morning very early to get the room set up. I know Nick was here with them the whole time, and a number of other people. So it does take a lot. And the Wi-Fi and the internet connectivity is not going to be able to be guaranteed, depending on some of the places we're meeting. I wouldn't know where we would necessarily meet in the Inland Empire, Richmond, Watts, or Bakersfield, Allensworth. So that's also a consideration in terms of if we want, you saw what happened with the witnesses that were giving testimony. And that's not a small thing when people prepare their testimony and they want to be heard. And we have a lot of people who want to hear from them. It can become very difficult.
I wouldn't raise this issue because these are really important places to meet. They are. But now to get this done on time is a sprint. It just sounds to me. And to the extent that having it in, I'll call it inconvenient but desirable locations, if that greatly impacts the schedule for everybody, and including for task force members to get the job done, then I think we have to consider the balancing of that. Whether being in a location is worth the impact on the schedule and the stress that it would cause when we've got all these deliverables that have to be done within a fixed period of time. So the schedule looks very challenging to me right now.
I'll also say in terms of our challenges in getting a quorum for this meeting, obviously it's been several months since our last meeting, and it's going to be several months until the December meeting based on quorum. That would be something else to take into consideration. And we could, if you wanted us to do the poll for in-person and virtual on a meeting by meeting basis, if you wanted to consider that.
Madam Chair,
Vice Chair Brown, you're recognized.
I would like to suggest that we consider that this decision be dictated on the basis of the convenience and make it hybrid. And the staff would immediately do the research to let us know. And number two, that we will look at the importance of and the timeliness of the issues that we have to deal with, and the decision be made on the basis of that. First, the main thing is the functionality, the practicality of our meeting in person over gangs, doing the virtual.
So when you say research, are you saying research into the feasibility of finding locations in each of the cities names?
Yes, immediately. Let us look at whether it's practical.
Just a point of clarification, are you, Vice Chair, are you talking about doing sort of switching off, having one in person, then one virtual, then another in person?
Based on the practical, the ABC 1, 2, 3 of having a meeting.
That's what I was talking about, you see?
Yeah, I think he's saying based on the practicalities, not necessarily on the convenience or whims of what you want to do or not. You know what I'm saying? Like, so then that does require actual research. Like, it's not enough to say we don't know where we can have these hearings in San Diego or Sacramento. I think there needs to be some research to go into what potential locations would be.
Chair, that's what the Vice Chair was saying. Right. Excuse me, that based on the immediate facts given to us, the decision be made.
So I think that makes a lot of sense in terms of trying to figure out locations. I think that's a really important factor. I agree completely. And we can, look for those locations. Again, as we did the first meeting when we were going to select where we were going to meet, we talked, and I think that's, Vice Chair, that's where you first suggested the church in San Francisco. I think Exposition Park generally was suggested for Los Angeles. I don't think we had then specific suggestions going out from that, but essentially whatever the task force votes on, we'll make happen.
Well, but time is of the essence. I guess what I'm looking for is I so appreciate your willingness to do whatever the task force asks of you. But my question is more like, what's going to negatively impact the schedule if time is of the essence? And do you have a recommendation? I'm just going to throw out something crazy, just thinking out loud. For instance, if it matters, if we met like every meeting in Sacramento, you know, and that greatly facilitated the schedule and it relieved the stress on everybody. Is that a factor, for instance? And if that, given people's availability in the schedule, maybe that should be a consideration.
I mean, that would certainly be much more doable. Our team that puts us on in Sacramento is in Sacramento. We'd have presumably locations where we could do this in Sacramento on a regular basis.
I think we need to do some polling amongst the task force, because I think when we originally set out to do in-person hearings, the reason why we decided to list all these different cities is because we wanted to meet the community where they were. So, you know, meet folks in Oakland if they couldn't, you know, go anywhere else. Meet folks in San Diego, meet folks in Sacramento, meet folks in Inland Empire, meet folks in Richmond or Inglewood or Allensworth. But now I think what you're saying, Member Tamaki, is that you think that we should revisit that plan.
Well,
because
I guess given the schedule, you know, that I'd love to do that original plan if it's, you know, doable. But given the schedule, I guess I'm asking, is it still practical?
I agree with that. I mean, I initially suggested Allensworth, but I think that's going to be a tall task to try to pull this meeting off in Allensworth. And I think we would be better suited if it were in Sacramento or in Los Angeles again, where people can readily access it and be there. So I would move to even scratch Allensworth, because I just think other than historic location, we gain nothing there, even from a population standpoint.
Variables went into how we organized it. Like, so for instance, with Allensworth, we were also thinking about the fact that that would be technically the last meeting, although it might not be anymore, but that we know that that will be the meeting when we release the final report. So for purposes of optics, education, Allensworth was an important consideration. But, you know, there are other places. Oh, I'm sorry. But, you know, I agree generally that we may want to revisit some of these places that do seem too inconvenient in terms of the burdens and benefits. But there is a burdens benefits analysis that should go on. And I think one of the things that we should be thinking about in terms of burdens is, you know, leading up to that meeting, what is going to be the workload that each of us is facing? So I know that May is going to be the month from hell, right? So we should be thinking about, that's how I'm sort of organizing it. I imagine that December is going to be difficult because of people's family obligations in December. So that adds another variable to think about. And we should always, you know, virtual is a possibility that we should all be thinking about, you know, doing virtual in lieu of in person on some of these meetings where we might not have as many benefits from going to a remote place.
So I think, just for your schedules, based on this schedule, just the schedules, probably going to be the most work for members of the task force leading up to the February meeting, because that's where your initial presentations will be for the outlines and discussion of your proposals. And then from February to March is going to be, based on our experience in the first time, the sprint, where we're really taking all the recommendations from the task force, from the discussions of the outlines, and finalizing the draft. So February to March meetings is going to be a sprint. That's going to be a big workload. I mean, most of that will be shouldered by our attorneys who will be, working at your direction. But where you're going to have to be giving us a lot of feedback and making decisions on how things are going to be written, and then a lot of reviewing and editing and commenting, and then preparing your presentations back to the task force in the March meeting when that initial draft is presented, is probably going to be the most work. I'm hoping, like with first interim report, the feedback that we got once we presented that initial draft was pretty complimentary. I think people were pretty much on board. There were a number of edits and feedback, but I think we were pretty good at that point. So I do think if you were to consider it, the February meeting might be a meeting where being online and you all not having to travel and being able to use that time, may make sense. I was just talking with Trini, and obviously we can, like I said, we can find locations, we can find places to do it. I think as we've experienced, where we're going to have witness testimony and presentations online, probably facilitates that better, because they have the ability, we're all online, they're online, and there's a much easier ability for them to communicate with everybody in the virtual space. But where we're maybe going through reports and sitting and writing through and meeting with one another about that might make more sense in person. We can, I'm very hesitant to steer you in any direction. It's really your determination. Mm-hmm. We will make happen whatever you all vote on. I want to make that very clear. The idea is just to make sure that these meetings are done in a way that allow you to take care of all your work.
I just want to be open in that my concern is that if we decide to go all virtual, which I'm not saying that that's what we're doing. My concern is that we're potentially depriving the benefit of the public for us to meet them where they are, and kind of over-privileging what the DOJ thinks is convenient or not to do. The statute says, you all are supposed to give us technical, legal, and administrative assistance, and there's additional money provided for that. So that I'm just being transparent about how I feel. I do think it is difficult, not only for the DOJ, but task force members to kind of, meet in person in these locations. But I do think in part is necessary in order to meet the public where they are, and to benefit folks in the public. Because for instance, there's people who are emailing me all the time. When are you guys coming to Oakland? When are you coming here? When are you coming there? So it's just what I'm thinking.
That this matter will be determined on the basis of the practical arrangements and what's humanly possible to deliver, and that we would get back from the staff what their analysis is and give it to you, and the decision be made by you.
So just to clarify, so we have the December meeting is currently scheduled for Oakland. That's that needs to be decided today, obviously, whether that's going to be in person or virtual. And Vice Chair Brown, what you're suggesting is we sort of put together based on
what I'm saying is that even for Oakland, if it's just not humanly possible for us to have a meeting and that thing will function, we'll be able to connect with the public. It would make sense to even look at Oakland. We'll go virtual.
Also, I have a quick question. If we go virtual, will we do the blue jeans or are we going to do the new system, DOJ Zoom?
Are we?
I will make it not.
Okay, Member Grills and then Member Bratt.
So I was wondering if we could maybe consider a hybrid option in the following way, because I think some of the in-person is important. And so I'm also mindful of what was said earlier about the crunch time coming around February, March. So what if the December, the January, and the February meetings were in person in various locations? And then from there, the March, April, and May are virtual, which allows us to still have our meetings, but we're not using valuable time that's going to be needed to write and edit finish up the report. And then we go back to in-person in June.
I was thinking, what about, I just have a question. Did you consider like flipping it? Like what it would look like for the first 3 months to be virtual and then the rest would be, I'm just curious if you like consider if there's any real thoughts on
If
that.
we flipped it though, in flipping it, we're gonna be knee deep in trying to get that report out the door. And I just think that, the travel time and the staff having to take their time to go to virtual, in-person spaces would be a drain.
Towards the end of the process rather than the beginning. That's what you're saying.
Yeah, so we go virtual toward the end, except for the very final meeting. So in December, January, and February, we continue with in-person, decide on the cities, and then March, April, and May, we go virtual, which, allows the staff to stay focused and us not to use travel time. That travel time could be used for report work. And then in June, we go back to in-person.
Maybe we can do a poll on that suggestion.
Motion that Dr. Grills' recommendation will be adopted.
So it has been properly moved by Member Grills and, it's been properly moved by Vice Chair Brown and properly seconded by Member Bradford that we adopt Member Grills' plan, and that plan would be the first 3 meetings, December, January, and February, remain in person, and we can decide the locations. The March, April, and May meetings will be virtual, and then our last meeting will be in person. Is there any discussion on the matter?
The one thing I just want to confirm for the in-person meetings, Oakland, San Diego, and Sacramento are going to be the best for Wi-Fi and connectivity. So I think, and the location and hotels and all those things. So I think I would say this. Can you confirm that those locations are going to still correspond to those dates as part of the motion?
Okay, that's the question. So I'll go to Parliamentarian Johnson for a roll call vote, and we'll address that in a different motion.
I'll begin with the chair.
Aye.
Chair Moore,
Aye.
Vice Chair Brown.
Yes.
I'm sorry, sir.
Yes.
Thank you.
Member Bradford?
That's here. Just use this.
Aye.
Thank you. Member Grills? Aye. Member Holder? Aye. Member Lewis?
Aye.
Member Montgomery Step,
Aye.
Member Tamaki.
Aye.
Madam Chair, there were 8 members present and voting, 8 ayes and 0 nays.
Thank you. There were 8 ayes and 0 nays. The ayes have it and the motion carries. Our December, January, and February meetings will be in person. Our March, April, and May meetings will be virtual, and our final meeting in June will be in person. So I guess now to go back to Attorney Newman's comment on confirming the locations for at least the first three in-person meetings. Maybe we can also solidify where our final location will be for our final hearing, or we can do that at a later date.
I thought that was part of all of the motion.
That, for San Diego, I also have staff available and additional folks from the mayor's office and all of that. And we've been brainstorming locations, and we'll just definitely keep in mind, what's really important to me is that we hear every single person that has prepared to come, that we've invited to come, and that we be able to take in that testimony fully. And so we'll just keep those in mind, but we're available in San Diego, so that shouldn't be an issue at all.
I would just recommend maybe getting in touch with District 3 Councilmember Carol 5 to see if she can help the DOJ and the task force in accommodating logistics.
Thank you all for the recommendations and support.
Okay, so the locations will stay the same. There needs to be a motion for that since it's already on the page. Are there any other comments or questions from the DOJ?
Oh, if you wanted to, you don't have to decide that now. You can decide at a future meeting. But if you wanted to have the June meeting somewhere near Allensworth, that was something that was discussed a few times during the process. If that's what you want to do for a commemorative meeting where essentially that meeting is going to be releasing the report.
That'd be nice. Final. Yeah, that's going to be the final, yeah.
And we'll need time to figure out where that's going to be as close as possible.
So I wanted to, I'm not sure if this would go here or not, but in terms of the meeting agenda, I'm wondering if the task force might consider including in our agenda the following: building in some time, whether that's 2 hours in the existing 2-day period, whether that is adding a half day, adding 2 hours in the evening, but that we open the space, focus solely on personal testimony related to the 13 areas of harm. I suggest that for a number of reasons, but I think that being able to have those personal stories will deepen our understanding of the nuance of how these things are operating. It could also help us to have greater empathy and sensitivity to what we have been talking about with these different areas of harm, but it's been from the perspective primarily of expert witnesses, academics, experts, etc. And we did have periodically a few examples of personal testimony in the beginning, in our first year, and I think that it was pretty powerful. And remembering what our witnesses said this morning in terms of the Japanese reparations, one of the most impactful components of their efforts was that personal testimony. In particular, it built community within the Japanese American community, and it also helped to educate the public. So it spoke to people's hearts as well as their minds.
I think that's a brilliant idea. Thank you for that suggestion.
To that, when we say personal stories and relating back to the Japanese American hearings that were powerful. The personal stories are different from positions or exhortations. In other words, in the Japanese American hearing, there was witnesses who talked about a brother who walked too close to the barbed wire fence line, and from 300 yards away, the sentry took aim, shot, and killed him with a single shot in the chest. People had not heard that before because no inquest was held, and the guard was exonerated. Here, for instance, in the interim report, you have the Odell Short family, for example. In 1943, they move into a house that the Odell family built. And the sheriff says, if I were you, you need to go back to your black neighborhood. Vigilantes warn him to get out. 2 weeks later, as disclosed in the report, there's an explosion. Witnesses see the mother, Helen, trying to beat back the flames, consuming her children. All family members died. San Bernardino Police Department concludes it was an accident. The Attorney General concludes no evidence of vigilante activity could be found. You know, those kinds of stories, and the stories of people here in this room, frankly, that people have actually gone through, whether it's the Great Migration of grandparents, or whether it's, you know, current day. We heard some testimony in the listening sessions about a father turned down by 3 or 4 landlords trying to move out of the neighborhood because gang members were threatening to kill his son. You know, I think that's different. That's a different story than an advocacy or an exhortation or an urging or something like that. And so we dealt with that too, and tried to make a distinction between, you know, actually disclosing the human side of what happened and the consequences versus taking a position. And so I think what you're talking about is something like that, which means that some careful attention has to be gotten to get people who are willing to share their story. And maybe they never shared it before because it's so damn painful. And for those people, coaxing them out, or maybe not, but you know, in our struggle, we actually worked with those witnesses. We helped them get prepared, and we made sure the press was there and cameras were on. And so when the country saw that, it did move the needle of public opinion. So there's a difference here between even our public comment, even the comments in the listening session, and personal stories. So if that's what you're talking about, I'm totally with you.
Yeah,
Just based upon my experience.
Yeah, that's what I'm talking about.
So was that for just one hearing or over a series of?
Well, and I guess it raises a question about whether we could actually do this effectively within the context of all the business we have to do in our public hearings. But if you're asking me about the commission hearings, we had 10 of them in every major city, and they were 1 and 2 day events. So I think we have to talk about how practical this is, and if it is not practical, I would still urge this task force to find a way and get it funded to hold a different kind of hearing. And if anybody's interested in video clips of the hearings that we had, they're quite dramatic. I mean, in some of these places, there wasn't a dry eye in the room when people got through, you know, testifying. And some of the people had sort of been so hardened to it that when they testified what they went through, they didn't think so much of it, but others who heard it, it moved them. So I guess my point is, member girls, I think you're onto something, and we have to determine as a practical matter whether it fits within the context of a hearing when we've got all this stuff to do by June of 2023. And if it's too much to shoehorn in there, something this important, then maybe we ought to be thinking about another kind of thing. And it could be, again, I'm not sure how we do this on the schedule and everything. But maybe there is completely separate where you devote a day to this kind of thing, or multiple days.
Right, I was thinking that if we did something that was consistent with the 3 in-person meetings, we would then have the opportunity to hear from people from different parts of the state. It might require us to, extend like day 1 and have after dinner an evening session that was devoted just to this. That would have then allowed people not, to attend and not have to miss work, and more of the community could hear it and see it. Or we add an extra.
And make sure the press is there.
Yeah.
Yeah.
Madam Chair,
Vice Chair Brown, you're right.
all we have to do is extend the invitation. People will show up. Just let them know. They will be here. All we have to do is let them know, get the word out, and know the network that really gets the word out and cover all 4 corners of these communities. They will come, but we got to get the word out. Visually, orally, and written.
Okay, so I think we need to move on, but we're already discussing what we need to move on to, which is the agenda for the next meeting. But yeah, just to tie up loose ends, I think, again, what Member Girls offered is brilliant. I'm personally in favor of those evening sessions after the 3 in-person, after each of the 3 in-person meetings. We also are in the process of hiring a communications consultant. So in the event that we wanted to do a separate event, in light of what Tamaki said, we could work on that through them. There's also probably space and time at our final hearing, where press definitely will be there in full, and we could allow space and time for additional personal testimony on those 13 areas as well.
More, excuse me. For the December meeting, we have the quorum for the Wednesday, Thursday, and Friday. Perhaps what you are suggesting could be accomplished on a Wednesday evening before the meeting, because we don't have any current availability for it after the meeting. And maybe in future agendas, it may be the day after. But if you wanted to schedule something like that, we could do an evening session on Wednesday for the personal stories, and then the task force would meet on Thursday and Friday.
Okay, thank you for that.
Are we meeting on Tuesday evening?
For December, the quorum is on Wednesday, Thursday, and Friday.
Thursday would be better.
So then that would just be an evening session following the conclusion of the task force business.
So this agenda still says November, but would be December, right?
So the agenda that was circulated, because of the votes and the way everything's been set up with the advisory committees during this meeting, doesn't necessarily reflect the conversation. So the task force can really do whatever it wants with this agenda. It still could work if you want to have a testimonial focused meeting. But we will need to add in time for reporting out from the experts and advisory committees on the interim and final recommendations as we laid out in the future meeting plan.
Yeah, so again, this is just me thinking out loud, just based upon what our community went through. If we do this, it should be done with some care. It should be orchestrated and prepared. In other words, if we just call for people to come out, it might work, it might not work. You know, we, in our community, we had to identify people who had good stories and arrange for the press to be there, arrange for community support to be there. It takes a lot of work to do that. So, you know, it's produced, actually. The stories are authentic, they're accurate, they're true, but it still has to be produced. And, you know, you gotta have also the media there. So there's a fair amount of preparation that goes into this. So if you make this commitment, that means we really gotta get behind it. And if it's in Oakland, to work with local folks there to identify, you know, some key people. I mean, others could be there too, but identify key people that really, really have compelling stories. And there are there, but people have to be approached. So that's just, you know, one caution I want to throw out.
I think that would be too soon to try to come up with this by December in Oakland.
Excuse me, Madam Chair.
Yes.
I'm in Oakland. I know the Bay Area. I've been there for 47 years. But seriously, this is not being arrogant. We have quality, competent publicists that we can put to work. Number two, we have a built-in network that has many tendrils out there. Trust me, we know how to work miracles. So we can do it.
Okay, no, the only thing I'm gonna say, okay, we can do it. I was gonna offer, we can do something for Black History Month in February. Since that meeting is gonna be virtual, we can do maybe a in-person event. It kind of corresponds with Black History. It gets people riled up and ready for our June release, but we can do in October. I'm totally fine with that. And then I was going to suggest, as a happy medium, to incorporate Grill's suggestion, we just extend public comment for the rest of the 3 in-person hearings. So my idea was we extend public comment for the December, January, and February meeting, and we do an orchestrated event in February for Black History Month or something like that. But that's just my idea. I don't dictate or decide.
Madam Chair, are you saying hold the February meeting on a certain date, or are you saying use that February meeting for a Black History Month event as well?
No, I was saying the Sacramento meeting would stay as is with that particular topic, but then there would be an extra event or like an extra day. But I'm really just thinking out loud, and I would like to probably defer to Vice Chair Brown or anyone else who has some other thoughts around what we could do. Another thing I just want to get out there, I think, which corresponds with what Mayor Lee said, I want to get you all's thoughts as my fellow task force members about the idea of inviting different leaders throughout California who are heading municipal, city, or county reparations initiatives across the state.
Yeah. Well, we had Michael Lawson here yesterday, who's heading up to City of LA's Reparations Task Force and also is the president of LA Urban League. So I'd probably be key to invite him back for our next meeting as well, or at the appropriate time.
So I had a question to the attorney. So for the December, the December meeting where there's 2 witness panels, do you think that could potentially be an appropriate time to invite, these city and county leaders of different reparative justice measures that assist in our work at all at that particular time? I don't know.
So first of all, you all can set the panels however you wish. I will say, I think there's 2 different concepts. For our purposes, it would be good to know. I think there's a discussion about specifically inviting and welcoming specific individuals with stories as opposed to just an open forum. That's important for us to get clarification on exactly what the plan is. And of course, we'd be looking to the members, as with all the witnesses, to tell us who to be in touch with, to invite to offer personal testimonies as you're talking about. So I think that would be very important to be very clear on, that it's a intentional inviting of specific people with experiences rather than a forum. And then in terms of the witness panels, so I recognize that the witness panels on the future hearing schedule that we just worked through are different from the witness panels that are in this meeting ahead plan. Can you scroll down a little bit? They're different from the witness panels that are that were delineated in your materials. My message to you is, however you want to schedule that meeting, however you want to set that meeting up, we just need to make sure that we have time for the work in each of the coming meetings. So probably one day reserved for reporting out from the experts and the advisory committees on interim or final recommendations. So the delineation is going to be probably need to be 1 day working day and 1 day witness days, a little bit like this meeting. But I want to make sure you all have time to hear from the other advisory committees, weigh what's being discussed, and make the decisions that'll need to be made. And I wanted that to cut into witness testimony.
I think it's important. Hello? Okay. I think it is important to try and liaise with, the different municipal organizations that are working on these questions. I think it would be opportune to do it in an open meeting, given the fact that in the Bay Area, there are several different cities and counties who are working on some variation of a local reparations initiative. There is Cal 5 working on kind of like a Black New Deal program in Oakland. There is, of course, San Francisco and Alameda counties, respectively, working on their initiatives. There's the city of Hayward working on a Russell City initiative. So I think, given that those are like 4 or 5 that I just named, they're all in the Bay Area. So it could be opportune. And then I know what's happening here in LA, but I think just taking a view as to geographically where some of these initiatives are, having that happen in Oakland might be beneficial.
So would that look like just an additional panel or reserved for those leaders, or?
I don't think you necessarily need an additional panel. I guess the idea is this, the delineation of panels was key to sort of an earlier plan. So you can pull away from those panels and just start from scratch with panels.
But what about this plan where it says witness panel 1 and witness panel 2? Those are still on the table, right?
Yes, you all can do whatever you want.
No, okay, great. I understand that. I was just wondering and just making sure. to ensure that we have something on our agenda that is going to help move this process along. Okay, so let me go back. So I think based on what we just discussed, I think we should have a space on the agenda to invite leaders of these municipal reparations programs across the state. I think when we had our public hearing in San Francisco, you got pressed out. And so I think there is an opportunity for us to have that type of orchestrated event because there are connections there. So what I'm proposing the agenda might look like, of course, is one, we have the report out of the different 10 committees. We invite these municipal leaders, and then maybe the following day, we have that orchestrated event where we allow folks to provide that personal testimony. Is there anything that I'm missing? Is there anything that should be changed? Oh, in the evening. Okay.
Right.
Okay.
Chair Moore, just to clarify, are you saying the witness panel on that Member Lewis was just talking about, as well as the 2 witness panels that we talked about on this plan, or scrap those 2? But then we do, like I said, we need to make sure we have a lot of time for the task force to do the work for the report preparation.
Yeah.
So like that's probably one day.
Okay. So so that's just me misunderstanding, because I thought witness panel 1 and 2 were related to the committees that we just made, but they're not. They're separate. Witness panel.
I'm sorry.
Witness panel 1, testimony and suggestions regarding potential remedies and remedial programs. Witness panel 2, legal, legislative, and program administrative experts' suggestions for addressing harms delineated in the report.
That would essentially be similar to the witness testimony in the first phase, where that witness testimony would inform the final decisions of the task force as to the reparations plan. So those witnesses are in furtherance of the work of the advisory committees. But then the advisory committees will need, according to the plan that we've set out, to present their preliminary discussion. So the idea might be 3 witness panels on the first day, and then the second day for the advisory committees to report out and have the task force discuss all of the different issues. And then if you chose to have the personal testimony, that would be the night of the first day of the meeting. So it'd almost be like day 1, night 1, day 2.
Okay. And just to further clarify, so I'm understanding, those first 2 panels, the folks we're inviting to give testimony, not the municipal leaders, but the people we're inviting, would they be our already retained experts or new people that we would be inviting?
You'd be inviting other people with experiences outside of the task force to offer their testimony. Again, it's similar to what we did in the first phase, where we had people coming and testifying about what turned out to be each of the chapters in the report. You would have experts who have handled the allocation of remedies or operated remedial programs or engaged in legal or legislative advocacy on a variety of different harms. So you'd be inviting testimony from experts. The economics experts would be part of essentially the other day that they'd be weighing in on the recommendations of each of the advisory committees.
Okay. Okay, so to recap, in Oakland, the first day would be dedicated to those 3 witness panels. So the first 2 witness panels that are already on the page, and the third would be inviting different municipal leaders of reparative justice initiatives across the state. And then that evening, we would allow for a space of orchestrated personal testimony and invite the press. And then the second day would be relegated or dedicated to the 10 subcommittees, advisory committees reporting out the work we will be doing or we would have done between now and our December meeting. Okay.
That's correct. And then if you want to have the special invited personal testimonies, you have to figure out where that'll be in terms of the agenda at night.
Day 1 at night or day 2 at night, you're saying? I'd like to acknowledge member Reggie Jones Sawyer.
I'd like to make a motion that we officially adopt that as our schedule.
We have to decide what night do we want the personal testimony, day 1 or day 2? And you said it's, what days are quorum?
Just to clarify, you have a quorum on December 14, 15, and 16. So it'd be 2 of those days for the meeting. Wednesday, the 14th, Thursday, the 15th, Friday, the 16th. And you have to decide which of those days you want to have the meeting on, and of those days, which of the days you want to have the special session, if you want to have it in the December meeting.
Definitely, I think Dr. Brown said Thursday night, but definitely Wednesday or Thursday night.
Okay.
Because Friday, I will say I would not want to do that. Wednesday or Thursday.
Okay, so the first day of meetings will be Wednesday, and the second day of meetings will be Thursday, and then we would have the special event Thursday evening. Is that what we said?
That's it, yes. That's
Okay, okay. So I entertain a motion on this.
I move that the stated schedule will be adopted.
It has been properly moved by Vice Chair Brown and properly seconded by Member Bradford that are, by Member Reggie Jones Sawyer, excuse me, that our next meeting will be in December, on December 14th and December 15th. That's a Wednesday and a Thursday. So the first day, December 14th, would be dedicated to 3 witness panels. The first 2 panels we've already discussed, that's on the page. The second or the third panel would allow for us to invite municipal leaders of different reparative justice efforts across the state. And then the second day would be dedicated to the 10 subcommittees that we created this afternoon to give out reports as to the work that we've been doing over the past 2 months. It will be. And then that night, Thursday evening, we will have that special event inviting folks to provide personal testimony on the 13 harms or atrocities outlined in our interim report. And we will invite press. Is there any discussion on the matter? Hearing no further discussion, I'll turn to Parliamentarian Johnson so we can establish a roll call.
Thank you, Madam Chair. I will begin the vote with a call with Chair Moore.
Aye.
Vice Chair Brown.
Aye.
Member Bradford.
Aye.
Member Grills.
Aye.
Member Holder.
Aye.
Member Jones Sawyer.
Aye.
Member Lewis.
Aye.
Member Montgomery Step.
Aye.
Member Tamaki.
Aye.
Madam Chair, there were 9 members present and voting. There were 9 ayes and 0 nays.
Thank you. There are 9 ayes and 0 nays. The ayes have it, and so the motion carries. The next item on the agenda is unfinished business and potential action. I don't think there's any unfinished business, but I'll ask the DOJ if there is. But since Reggie or Member Jones Sawyer is here, I wanted to ask Member Jovan Scott Lewis if he could update Member Jones Sawyer on what we discussed in terms of the 10 subcommittees or 10 advisory committees. No? In terms of what? Because we assigned you work, so. Okay.
It's right in your wheelhouse. I'll talk to you about it. We're working on it together.
Okay. All right, I guess people are ready to go. All right. Go ahead. Okay, so, did you have something?
Yeah.
Go ahead.
If we're still on unfinished business, I know that stuff got moved to unfinished business yesterday. And it's also related to what we just discussed, which is the next month's meeting. I think that, given the fact that there's legislation pending that could change the scope of power and work and the time frame of AB 3121, we have an obligation to discuss the change as a task force. And if and when it happens, I think that, we're going to have to address it as a task force and think about how it's changing our scope of work, adding to our powers, and adding to our time frame. So I think it's going to be important for the next meeting, when we will have definitive information whether or not these changes and amendments are occurring, that we reserve time to discuss and, if necessary, take action related to the new powers authorized in any amended legislation. So I would move that we reserve time in the next meeting to discuss that issue.
Clarification on that. The governor may not sign that, so it just sounds to me like, oh, wait, hold on. If the governor does sign it, we absolutely have to discuss it. If the governor doesn't sign it, it's a moot point. So I guess the motion would be, the safest motion would be a contingent motion, that if the governor doesn't sign, it appears an agenda item because there's nothing to discuss. But if the governor does sign, I think we have a duty to discuss it. So if the parliamentarian can provide some guidance as to whether such a contingent motion is appropriate, it seems to me that if it is, that would be the appropriate way to frame this. And it becomes a non-issue if he doesn't sign. But if he signs, I think vetoes it. If he signs it, then I think we're duty bound to discuss it, because it's the change in the law.
Yes, if the bill is signed, then it would be relevant to the motion that would be made. It would be appropriate. So if you do a contingent motion, then it would be framed that in the event the bill is signed, then you would like an agenda item to discuss whatever it is your motion is.
Okay, so then I'll craft a motion that in the event that the bill is signed that amends the powers under AB 3121, we reserve 60 minutes in the next meeting to discuss and if necessary take action related to those new powers authorized in any amended legislation.
That is fine. I would recommend that you put the bill number in so that you know what bill you're talking about.
22, can you
2296.
interlineate 2296 so I don't have to say it all over again? So, okay.
No, we'll just put the bill number in.
Okay.
Okay. Yes. Well, that's the chair's prerogative. The chair is now right for a second.
It has been properly moved by Member Holder and then properly seconded by Member Jones Sawyer that if Governor Gavin Newsom signs AB 2296 into law, 60 minutes will be reserved on our agenda for December to discuss next steps. Is there any discussion on the matter?
Yes. I would like to speak in opposition to that. Why waste energy and time on something that has not happened? If it happens, it happens. We should take it in my estimation, one day at a time. Because basic and fundamental, as I've said all along, it's just my little opinion. It was not necessary. Now, why should we spend our time discussing something that hasn't happened? And if he does, then we have to deal with it.
Make a comment.
Or, yeah.
So I think you're absolutely right, Dr. Brown. If it's vetoed, then it doesn't, according to this motion, it's not on the agenda. We waste no time. But if it is signed, we won't be able to discuss it in December because it hasn't been agendized. It's my understanding, the way it works.
That's correct.
So the safest thing to do is to pass a contingent motion that gives the possibility for that option. If it's not signed, nobody wastes time on this. If it is signed, I think we're duty bound as early as possible to discuss it. And the task force may decide to do nothing, but at least it should be on the agenda for discussion. But provided that it's signed. If it's not signed, no discussion.
Is there any other discussion on the matter? Hearing no further discussion, I'll go to Parliamentarian Johnson to establish a roll call vote on the motion.
Thank you. Chair Moore,
Aye.
Vice Chair Brown,
No.
Vice Chair Brown votes no. Member Bradford,
Aye.
Member Bradford votes aye. Member Grills? Aye. Member Grills votes aye. Member Holder?
Aye.
Member Holder votes aye. Member Jones Sawyer?
Aye.
Member Jones Sawyer votes aye. Member Lewis?
Aye.
Member Lewis votes aye. Member Montgomery Steppe? Member Montgomery Steppe votes aye. Member Tamaki?
Aye.
Member Tamaki votes aye. Madam Chair, there were 9 members present in voting. There were 8 ayes and 1 nay.
Thank you. There are 8 ayes and 1 nay. The ayes have it, and so the motion carries. In the event that Governor Newsom signs AB 2296 into law, there will be a discussion on the matter at our December meeting for 60 minutes. Thank you. So now we're at the last item on our agenda, which is closing remarks from task force members. Thank you all, members of the public, for participating these two days. I also want to thank Member Reggie Jones Sawyer and his staff for assisting in these 2 days. Everyone give him a hand. All right. Is there any other closing remarks from our task force members?
I'm gonna say real quick, we also are available to gather people to tell their stories in San Diego as well, if that is needed, and we continue in that vein. Thank you.
Thank you. Hearing no other closing remarks, this meeting is now adjourned. Thank you all.
Well, family, it's been a long couple of days, but you guys hung in here. I thank you so much as my co-host in the chat. It's going to be great for the family to actually be able to review the chat. Once they go back through the archives, they'll be able to see your comments, your questions, hear my responses, etc. I thank each and every one of you of giving up 2 of your days to actually be here and to be a part of making history, so that you could tell your children and your grandchildren you are a part of making history. And the goal is to take what you learn from our efforts here and improve upon it in the way that we've improved upon the debacle called Evanston reparations. As the witness shared with you earlier, it's a nothing burger. They can't even generate enough taxes on marijuana for it to make a dent in anybody's freedmen experience in Evanston, Illinois. So your job is to take from what we're doing and improve on it until it's perfected. We've also got a call to action. There's a veto. If you check out CJEC's Twitter page, you'll see the call to action to veto AB 2296, which extends our remedy through 2024, thanks to Reginald Jones Sawyer. And he's amended it to pretty much replace whomever he chooses on that task force and replace them with whomever he chooses by majority vote. So we want to defeat that measure, and we want to put the pressure on Governor Newsom. And we've got something we can dangle over him. We've got something to hold him hostage to. That's the black vote. You don't deliver on this veto for AB 2296. You don't deliver on these reparations before you throw your hat in the ring to run for president, which is coming, then we're going to withhold the vote. We're going to weaponize the vote. We're going to strategize and weaponize the vote to ensure blacks all over the country withhold that vote. So we've got something that he wants, and he's got something that we want. So let's weaponize the only commodity we've got left, that vote. And time is running out on that commodity as the Democrats seek to replace us with immigrants. You see it happening on a regular basis. They're lying, saying the borders are closed, and the immigrants are saying they're wide open. So there you have it, family. I thank you so very much. I have to jump. I've got errands and nail appointment and thing as such. But I want to pray over us before we go. I don't know who's new to the space. Let me put a covering over us that the light of God surrounds us. The love of God enfolds us. The power of God protects us, and the presence of God watches over us. Wherever Freedmen and his allies are, God truly is, because family, you are the face of God, the voice of God, the body temple of the Spirit of the living God. Until we meet again, family, I want you to make it a beautiful, God-inspired rest of your Saturday and weekend. If no one's told you today, know that I love you black and I love you freedmen strong. Yes, I do. Until we meet again, family, I'm believing for each and every one of us a ton of peace, love, and reparations, 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 family. Peace. I'm out.